10/10/2025 order not complied, my lord.
Order not complied.
No, my lord. 8 weeks have elapsed. In the meantime, I have checked out. But I will need to seek instruction whether they have complied in the meantime or not. Your lordship, again, 2-3 weeks time, I will come. My lord, I will file compliance affidavit or whatever the position, because I need to seek.
Notice was issued in this matter.
Yes, notice has been issued.
Issued.
My lord,
Whether you are
No notice in the contempt.
First time it has come.
First time it has come.
Issue police notice.
My lord, lordship,
That's the law. We have already laid down that way. If they do not obey the court orders.
but I don't know the position.
No, I am not giving notice to you. It's a contempt matter. You, the government advocate, cannot appear like that.
Yes. No, but
Therefore, we are giving issue police notice. On the to the accused. Reasonable within 10 days. Within 2 weeks, yes. Within 2 weeks.
Instead of accused, my lord.
suppose contemners.
But you were a contemner.
Contemners. The alleged contemner.
On the contemners.
Alleged contemner.
No, but the rule uses the word contemner only.
Contemner.
Stays after it.
Because we do not know the position, my lord.
You amend things. Yeah. Contemner. On the next date of hearing, the contemner shall be personally present for answering the allegations. First time. However, presence of the contemner shall not be necessary if in the meanwhile compliance report is filed. Unconditional compliance report is filed. Coupled with apology.
The government advocate will not appear.
No, you cannot appear. There is a judgment of Supreme Court. But they can engage you after notice, because we cannot pay for defending those people who are violating the court orders. Therefore, if they want, they can engage you. You can, because they are personal. Parties are in person.
Within 10 days, my lord, we will ascertain the fact, my lord, whether, and we will come back, your lords.
Yeah.
Complain.
Are they contemners are personal parties?
Yes.
They should take their own advocates at their own cost, not at the cost of our money. Yes.
Item 2.
Item 2 million. I prefer 1 week time. The last chance figure. Real protection period. Another matter, contractor matter has not come. So only 1 week time as last chance figure. Your lordship, kindly you can glance to the order.
Only 16/10/2025. Name the order.
My lord. In the interlocutory application, he has stated that my name has not been reflected. I have no objection to that, my lord. You are very much present. My friend was very much present on the hearing. And upon hearing both the parties, then your lordship passed this order.
Now what should happen?
My lord, he has filed this interlocutory application that my name has not been reflected. So, and my submission has not been reflected. But that is your lordship.
His name is not been reflected.
That is, of course, your lordship. That is in the court title. But he was very much present.
Registration shows the name of. But you appeared and argued the matter.
My lord.
No, sir, I have not mirrored that. But I have some on the last occasion.
No, you had argued the matter.
Yes, I have argued matter, but your lordship directed me to take instruction. The last time your lordship may see whether because the order was particularly fast mirror on the basis of a similar situated employee of the university has been granted the same relief that shall be extended to the petitioner. That was the order mirrored in the case of Hon'Ble University case. Correct. It's a different university. We had not filed counter at that time. So my submission was mirrored. If
Now, what is the application?
application for recall of the order I had filed mirrored.
No, sir, you have to file review. Recall application is not maintainable. You have to file review petition under 47 rules 1 and 2, which are made applicable to proceedings.
Yes, that I understand. But the last occasion was directed to take instruction.
No, the subject application seeking recall of the final order passed on 16/10/2025, whereby the writ petition was disposed of. Is sought for in the present application supported by affidavit. First, it has been the settled position of law that the provisions of CPC 1908 are made mutatis mutandis applicable in the writ proceedings. And therefore, if there is any ground for review, a review petition has to be filed, not the recall application, as rightly contended by learned counsel appearing for the writ petitioners. First, next one. The second submission of counsel for the panel counsel for the applicant university, that his name is not reflected in the order, though he had argued the matter, is apparently true. First, therefore,
My submission.
registry to print the name of panel counsel in the final order by making necessary insertions and issue a free copy of the same to the university, to the panel counsel, if applied for. Next point. In the above circumstances, this application is disposed of, reserving liberty to the applicant to seek review of the said order, if grounds do exist therefore, in accordance with law. Disposed of. Yes. Over. 3-0. Yeah, at least inform the other side. Page number 30.
Interim order is there.
All after 4 weeks. Interim order to 30.
My lord,
Interim order to.
item number 4, my lord, I have filed caveat petition. Item 4, I have filed caveat petition. My lord, senior has saw the copy
Yes.
just now. May I pray, can it be taken up next week so that in the meantime I...
Please wait. 1 to 10 are not mentioned in any sensible course. Yes.
Item 1.
May I please, Your Lordship? Lord, I have challenged the order of the Honorable Single Judge by the annexure 3, my Lord, whereby my submission is, my Lord, whether the amending Act of 2023 to the Consolidation Act, deleting Chapter 5 and inserting a provision under Section 36A can take away the right which is already accrued to a petitioner, my Lord. In the present case, Your Lordship may kindly see Annexure 2, my Lord, page 16. The order was passed on 22nd July 2022 by the collector in exercise of power under Section 35 of the Consolidation Act, declaring the sale deed,
22/7/2022.
my Lord, Annexure
Order.
My Lord, Your Lordship may kindly see Annexure, page 17 of that Annexure, my Lord. My Lord, I am last portion I am only reading. In the result, as per provision of Section 35 of OCH and PFL Act, the impugned RSD number such and such are declared as void and the opposite parties are summarily evicted from the case land. Then direction has been given to Tahsildar and Solicitor to carry out the said order. Thereafter, my Lord,
Section 6 of General Clauses Act.
that is Central General Clauses, but our Odisha is,
Orissa, sir.
Five, my Lord.
You have also an act, no?
my Lord, 5, my Lord.
5 it is.
Yes, it is 5 in Odisha.
5 is on par with the 5.
Yes, yes,
Orissa
six,
is on
six.
par with center.
Yes, my Lord.
6.
Yes. Effect of repeal. Where any Orissa Act repeals any enactment here to made or hereafter to be made, then unless a different intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes effect, or B, affect the previous operation of any enactment so repealed or anything duly done.
But your section reads repeal of enactment,
My Lord,
not repeal of a chapter in the enactment.
my Lord, my Lord,
How courts have interpreted that?
my Lord. My submission is
Repeal of enactment means what?
as a whole,
As a,
my Lord,
here it not as a whole it is done,
my Lord,
but repeal is partial.
my Lord,
It is amendment.
my Lord.
Parent act remains intact.
Yes. But chapter 5 is completely related.
Chapter 5 is not enactment.
No, my Lord, no.
It is part of the enactment.
My Lord,
Whether to that also this repealing section applies.
my Lord, some decisions are there, even partial repeal, it applies.
Applies.
My Lord. But now, your Lordship may kindly see the Honorable Single Judge passed the impugned or judgment.
Issue heard learned counsel appearing one appellant. First of, he presses into service the provisions of section 5 of Orissa so and so Act. Orissa General Clauses Act.
General,
Orissa General Clauses Act, which year?
1939.
1939. And tells us that section 6 of General
Sorry, my 1937, my Lord. Sorry.
37 and tells us that the provisions of section 6 of the General Clauses Act 1897 are and tells that the provisions of this section of the State Act are pari materia qua provisions of Section 6 of the General Clauses Act 1897. And therefore, what has already been done under the unrepealed Chapter 5 of
The Consolidation of Holdings and Prevention of Fragmentation of Land Act 1972.
OCH and PFL.
My lord, is
not affected. First of all, matter requires deeper consideration. And thus a case is made out for issuance of notice and also grant of interim protection. In terms of application in IA number so and so, supported by affidavit. First, next one, in above circumstances, application having in favor, the parties are directed to maintain status quo.
my lord, is
Status quo till next date of hearing. We have copied to the date of form.
Item 2. I am party in person and appearing for the case of CPSC SI recruitment 2024. Recently, there is CBI investigation is going on for the corruption matter, but this corruption is continuing since 2018, and I am the aspirant in 2018, and now the recruitment come in 2024 after 6 years of gap. But we have challenged the age limit regarding the upper age limit in this SI form fill up. The age relaxation of 3 years given by Honorable Single Judge, and we have again challenged as it is in writ appeal 1403. On the as Honorable Chief Justice also allow me to implement the parties. I have filed IA 47, and my only objection is that we want a 4-year age relaxation, because sir, in your women category, their maximum age limit is 33 years in your women category, but they have discriminating us your men category. Your men category, they have only make the upper age limit is 28 years, which is we are challenging that if your women candidate is eligible for 33 years, their maximum age limit, then why not we? Because I am only 29 years old.
Read 15.3, Article 15.3, your Constitution. Women constitute a separate class. Therefore, 15.3 enables the state to make special provisions for women.
Sir, another thing is that they have already given 4-year age relaxation in PMT driver and constable post. So I want that 4-year age relaxation also in police SI age relaxation.
Notice was issued in this matter.
No
The application, notice on application commission for impediment.
Already
Your application in IA number
47, sir.
47.
I have already, Honorable Chief Justice already give me liberty that considering this seriousness, sir, file an IA so that.
So on that IA, you want to impede others to the petition.
Yes, sir.
Then notice has to go to them.
Sir, but they are going to conduct the examination very soon, sir.
Well, let them hold examination. It will be subject to outcome of the
Yes, sir.
petition.
Yes, sir. Hold the examination till further
Application.
date.
I think IA number so and so 47 of 2026, supported by an affidavit, seeks impediment of certain persons. So who are they?
They are in the
445
55.
as OP numbers 2 to 455 to the petition. First up, issue emergent notice to the proposed party, returnable within 4 weeks. First up, next paragraph. Petitioner party in person seeks interdiction of the recruitment process in question on the ground that there is a gross discrimination of male candidates female candidates. First off, he also tells us that relaxation was accorded in the matter of recruitment to police.
PMT driver, Odisha PMT driver,
And
Odisha Police District Constable for 4 years. But in SI they are given 3 years.
And therefore, such a relaxation needs to be accorded in this case as well. First off, learned ASC appearing for OPs, official OPs, opposes the petition, contending that the ongoing recruitment process cannot be halted since there is a dearth of hands in the public service, which in turn is affecting the public interest, and therefore no prejudice should be caused to anyone if said recruitment is made subject to list pendings. First, we agree with this. First, next, after service is served, notice is served on all the proposed OPs.
Sir, till the date examination.
The examination will go on, but it will be subject to the outcome of the petition. Next.
Item 3. Item 3. Kindly take up after lunch, my lord. Item 3. Kindly take up after lunch, my lord. On behalf of Mr.
Customer.
Yes, ma'am. After lunch.
Item 4.
I am catheter and my donor just saw the copy of me. Maybe take on next week.
Next week, at the request of counsel appearing for the hearing. Yes.
Item 5.
May I plead also?
Yes.
So here the appellant is challenging the input judgment dated 9/10/2020 passed by the Honorable Single Judge to the extent the imposition of penalty on the
Cost, not penalty.
cost, yes sir, cost of rupees 50,000 personal cost on the appellate, your lordship. Wherein in the impugned judgment there was no such explanation or any kind of reasoning mentioning there that cost should be imposed on the appellant. And
No. Power to levy cost belongs to the domain of the court. Whether costs are sought for or not, it belongs to the domain of the court.
yes, sir.
There are such judgments.
Yes, sir. Apart from that, if your lordship will see the prayer of the writ petition at page
You are agreed by the entire order or imposition of cost.
only imposition.
Then other prayer, how that's going to help?
Your lordship,
Why cost is imposed? Let us go to that relevant paragraph of the order.
yes. Page 28, para 27, your lordship.
28. The petition is accordingly disposed.
Page 28 of my appeal memo, your lordship.
No. The reason given by the learned single judge as to why you should pay costs, where we find it.
There is no such reason, your lordship.
No,
you read it. Yes, your lordship.
Nothing is stated.
Honorable Single Judge has rightly observed there is administrative lethargy from the secretariat, chief secretariat level to the record keeping authority. But why the appellate, first appellate authority, that is Tahsildar, should liable to pay cost, doesn't there, your lordship.
Now you read
Done.
26,
27.
27 is relevant.
Yes, sir. I'm saying 27.
Now read it.
Yes, sir. The travel of the petitioner reminds one of the plight of the protagonist Joseph in Kafka, celebrated by the trial, where he faces nightmarish bureaucracy that seems designed to confuse. Considering the manner in which petitioner was involved in unavoidable litigation in seeking information related to his representation dated 26/12/2017, addressed to no less than the Chief Secretary of the State, which is yet to be see the light of the day. It is directed that opposite party number 5 shall be liable to pay cost of rupees 50,000 to the petitioner. But why opposite party number 5?
Read fully.
Yes, sir. To the petitioner on before 9th December 2025. Proof of evidencing such payment shall be submitted to the registry. It shall be open to the government opposite party number 1 to recover the same from the concerned officer. Also, before going into the argument, may I permitted to place the prayer of the petitioner made in the writ petition, Your Lordship. If Your Lordship see the prayer at page 13 of the writ petition,
of the writ petition.
Yes, sir. After hearing the petitioner counsel issue writ in nature of certiorari or any other suitable writ, passing the impugned order under annexure 10 and 16, directing that penalty age provided under section. Here, Your Lordship, directing means directing the State Information Commission under section 21 Act 2005 be imposed on OP number 5 and 6. And disciplinary action is provided under section 22 Act 2025 be initiated against the sole opposite parties. Your Lordship, may I permitted to read section 20 of the Right to Information?
No, your opposite party here is 12.5.
Yes.
So there is that.
But prayer has been made, direction may be issued to the State Information Commission for imposition of the amount, Your Lordship. That says the prayer, Your Lordship. Specific prayer says direction may be issued to the Information Commission, Your Lordship.
Or directing that penalty as provided under section 21 RTA Act.
Yes,
be
Your Lord.
imposed on the OP number 5 and 6.
And yes, Your Lordship, what section 20 says?
Yeah.
Section 20 empowers State Information Commission to impose penalty, Your Lordship. May I read the section 20?
In this, who had imposed the cost?
The writ court, Your Lordship.
Writ court has always power to impose the cost.
But, Your Lordship, by hearing the party, why the cost would be imposed on him? There was no so cause was asked to the appellant, Your Lordship.
He is a party, OP number 5, as you are saying.
He was a party. But
He
why
was a
imposed?
party.
He was
He
a
was
party.
party.
Listen.
Yes.
Yes.
There is the question that he was not given opportunity.
But while imposing cost, Your Lordship, relating to cost, it was subject
It was not given opportunity of hearing. Learned judge did not tell you, I want to impose cost, what you want to say. It is not there.
No, Your Lordship. No, Your Lordship. And Your Lordship, section 20 says, may I read, Your Lordship? Section 20 says penalty, where the central
It is not penalty. This is cost.
but
Penalty, fee, tax, forfeiture, and the fine, these are all legal concepts. Those a common genus they may have, but they differ.
But petitioner has specifically prayed by invoking section 20, the penalty may be imposed.
Question is, what is imposed is not the penalty in the light of section 20. There are judgments which say penalty is something, cost is another.
Yes, Your Lordship.
Therefore, your first contention, section 20 does not authorize, does not come to your aid at all. What is imposed is not penalty. What is imposed is cost.
Yes, Your Lordship. It's a personal cost.
Cost.
It was directed to be deposited to the petitioner, Your Lordship. But apart from that, I was not being heard why the cost should impose on me.
That point alone requires consideration. What do you say, brother? Ray, what do you say?
Lordship,
He says, learned judge should have given an opportunity of hearing to me. He should have proposed that I want to impose 50,000 on you. Why it should not be imposed? That is not forthcoming here.
He's a party to the requisition.
No, he's a party. Therefore, he should have been asked that. It is not that he was abroad or on a ship. He was right in front of the judge. Judge, before imposing cost, should have put to him, brother, we want to impose a cost of so and so on your client. He would have said why it should not have been imposed.
It's not required, but Lordship, while adjudicating the matter, my lord, the honorable single judge.
It's not a reserved judgment. It's a judgment orally given in the open court.
It is reserved, my lord.
Reserved judgment.
Yes, Your Lordship. Hearing was on 11/9/2025.
Page 17, my lord.
And date of judgment was on 9/10/2025. But during the hearing, Your Lordship, there was no such opportunity was given to the appellant, Your Lordship. Why the cost should be imposed on me?
Any judgment ruling you have brought which says while court imposing costs in a reserved matter, it should put the party to the notice and then it can impose the cost.
So presently I have not brought, Your Lordship. But section 20, Your Lordship, section 20 says, provided that Central Information Commission or State Information Commission, as the case may be, shall given a reasonable opportunity of being heard.
That is penalty.
Yes, Your Lordship. Before any penalty imposed. Your Lordship, same rule applies.
No. Cost, penalty, levy, forfeiture, fine, tax, all their different concepts.
Your Lordship, I'll come with the judgment, Your Lordship. I'll come with the judgment.
You take notice, we are going to issue notice. First of all, counsel for the appellant, he submits that learned judge had not, learned single judge who had handed the impugned order had not given an opportunity of hearing before levying a hefty cost of rupees 50,000. And therefore, the levy is liable to be settled. First matter requires deeper consideration. First, issue notice, learned ASC accepts notice for one petition.
Number 2 to 6 million. I'm accepting.
One is a private respondent.
2 to 6. One is private and the other is
notice to.
7 is the Information Commission, my lord, separate panel council.
You appear for them.
No,
Let notice go, let them issue emergent notice to rest of the OPs. First, application for counsel for the petitioner process his application in IN number
4112 of 2025.
supported by affidavit taking stay of the levy of cost on the ground already mentioned above. First, the case is made up for giving the hearing protection, although conditional. First, in the above circumstances, application having been favored, the impugned order to the extent of levying cost of rupees 50,000 is hereby stayed, subject to petitioner depositing rupees 10,000 in the registry within 2 weeks. Deposit 10,000 in the registry. All right, I'll deposit. Next, Section 6. You have to bring judgment on the next day, differentiating between all these concepts.
Yes, sir.
Yeah.
May it please, my lords.
Yes.
There are 2 matters, my lords. My learned friend is in the first matter, and I am in the second matter. All arising out of the same judgment of the Honorable Single Judge. So if my learned friend allows me, I can start the same matter. It depends on, since he's number 1 in the...
Yes. And he's
No. I leave it to him.
Serial number 3.
6.
6. Yes.
Man, with his permission of my learned friend, my lords. The judgment of the Honorable Single Judge dated 31st
The foundational facts of the case.
Foundational facts are this, my lords. That I'll just place the first issue, the first paragraph in the judgment. If your lordship comes to page 37, annexure 1 of my brief, your lordship takes the second brief first, 1863. A short issue, your lordship probably also has delivered a judgment. The issue that arises for consideration in this writ application is this: whether senior unreserved category candidates can be deemed denied promotion to the higher posts under
Senior reserve.
Senior reserved category candidates can be denied promotion to the higher post under unreserved category, ignoring their seniority. Now, my lads, the facts are this. The petitioners in that case, that is the private opposite parties here.
Promotion is seniority cum merit or merit cum seniority?
Merit cum seniority is the...
Merit cum seniority?
Merit cum seniority with due regard to suitability. ODRS rules, my lords. It is attached, flagged here. ODRS rules are flagged here.
Rule 11. Rule 11.
Annexure 14, page 161. That is Rule 11. Rule 11.
Learned single judge has reproduced it.
Promotion to the
At page 101.
166. 166.
101 he has reproduced it.
Yes, madam. 101 probably has reproduced it. The judgment has reproduced, yes.
Promotion to the cadre of revenue inspector shall be.
Promotion to the cadre of revenue inspector shall be made on the basis of merit and suitability in all
Seniority.
with due regards to seniority from amongst the amines and assistant revenue inspectors of the district who on the first day of January of the year in which the committee meets, provided that the percentage of promotion of amines and ARIs, assistant revenue inspectors, to rank of revenue inspector shall, as really as possible, be proportionate to the total strength of such employees continuing on a regular basis in the district. Now, this is the rule, the genesis of the Mallards issue before your lordship, Mallards. Now, your lordship may also turn to another rule in the same Mallards, page 169, rule 22, reservation. Rule 22, that's at page 69, reservation. Notwithstanding anything contained in these rules, 1, vacancies shall be reserved for direct recruitment, absorption, and promotion. 169, page 169, running page 169.
Second.
On the second rule.
Second.
Rule we are handing over the rules for your lordship.
One Xerox copy. We don't hold the books on a very heavy page till evening. Get the Xerox of that 2 copies. We are requesting the bar members to view Xerox copies. First the title Xerox, then relevant rule Xerox, 2 pages. We can't hold them in cages in our hand.
Well, this is there in the brief itself, page 159, 169.
Yes.
In the second brief, your lordship comes.
Yes, second brief. In the second brief, it has come in.
Page 169. We have annexed the entire rule.
169.
169 in second brief.
With your brief task.
169.
We take your task.
Second brief ta diyo.
Second brief ta diyo.
1863.
Which rule you want us to see?
Rule 22.
Reservation.
2 months. Reservation. Notwithstanding anything contained in these rules, 1, vacancy shall be reserved for direct recruitment, absorption, and promotion in favor of candidates belonging to the scheduled castes and scheduled tribes, and shall be filled up as prescribed in the Orissa Regulation of Vacancies.
As prescribed in the 1975.
Mallards, ORV Act 1975 and rules prescribed thereunder. So, Mallards, the roster has been made applicable. Now, Mallards, take your lordships to the judgment.
What the learned single judge says, roster is
Honorable Judge proceeds on a analysis that says there is no embargo relying on Sanjeev Roy. Union, page 58. In a recent case, that is Union of India versus Sanjeev Roy, the Supreme Court held, on an analysis of the aforesaid cases, we summarize as follows. Whether a reserved candidate principally proceeds that since there is no embargo under the ODRS rules, the rules that were just being read to your lordships, for giving promotion to reserved candidates into unreserved Mallards seats. So therefore, there is no bar. In doing so, Mallards,
kindly repeat.
The Honorable Single Judge proceeds on the premise that the rules themselves do not make any impose any embargo.
Or against
reserved candidates to be promoted against unreserved vacancies on merits. Since there is no embargo in the rules, so therefore they can't be stalled.
Yeah, because the Apex Court said
that is
the rule is
Mallards.
A general merit candidate cannot put his hand into the seats earmarked for
Mallards.
Reserved category candidates can compete with the general merit.
On merits.
Yes.
Correct.
On merits.
Correct.
Mallards. So therefore, your lordship, that would beg the analysis, as I would submit to your lordship, that would beg the analysis. The question that has been framed, the issue that has been framed, Mallards, by the Honorable Single Judge, I would with great humility and utmost, Mallards, I'll submit, utmost humility I'll submit, that the issue itself has been wrong, may not have been correctly framed. The issue that arises for consideration in this writ application is whether senior reserved category employees can be denied promotion to the higher post under unreserved category, ignoring their seniority. Now, this judgment unilaterally proceeds on an analysis that whether they can be denied promotion only because of seniority. There is no assessment and there is no discussion regarding merits. That because your lordship's judgment also, I am aware of your lordship's judgment as recently as this is in Litu Behra case 24636 of 2024. Your lordship delivered the judgment on 3/9/2025. Your lordship's own judgment.
It's a single judge.
Yes, lordship single.
What has been held in this case?
No writ application filed, my lord. I found out yesterday.
If my learned senior kindly permits me to place this judgment. That's besides the point. That's not what I was placing. I was placing something else. Your lordship may kindly turn to paragraph 3.1. Everywhere the accent, my lord, your lordship will see paragraph 3.1.
Do you have another copy of that?
One copy.
I'm sorry, my lord, you're handicapped.
My lord, I have got the caveat. I am appearing for one of the opportunities. Here your lordship has taken into consideration seniority.
Kindly allow me to place. You hold your enthusiasm for the time being. Lordship, paragraph 3.1. Let's read this together. Petitioners inter alia. This is how your lordships are proceeded. Petitioners inter alia along with private opposite parties herein, were in favor for the very same recruitment. Filed advertisement number 13 of 2017-18 issued by the Orissa Public Service Commission. Petitioners figured at serial numbers 12 and 13 in the final select list dated 31/10/2018, whereas all the private opposite parties figured below, as reflected in the OPSC notice number so-and-so dated 31/10/2018 at Annexure 1. It is true that petitioners take their claim for appointment under reserved category since admittedly they belong to scheduled caste. It is obvious. This is where, my lord, they
figured above the private OP.
It is obvious. They figured above the private, not because of social status, but because completing merits in the entry-level exam. So therefore, there was a level playing field there. 335, Article 335 of the Constitution, that balancing factor, which has been emphasized in all the judgments, right from my lords Indra Shawni to Virpal Singh, all those balancing factor, my lords. On the basis of final select list, they came to be appointed as lecturers. Now, my lords, in this case, admittedly, the opposite parties were recruited on a special recruitment drive held only for scheduled caste, reserved categories, and that is how they came in. So there was no competition at that level. So there was no level playing field. There was no competition of merits, even at the entry level. So now, my lords, that is where, my lords, the analysis needs to be done in tandem with, my lords, Rule 22. The impact of Rule 22 has neither been examined by the Honorable Single Judge nor, my lords, your lordships. It has not been argued that way before your lordships. And it was not argued that way before the earlier bench also. That 22, the impact of 22 and the ORV rules has not been placed before your lordships, and that has not been examined. I'll place that.
See 22.
22 of the ODRS rules, the rules that we were just placing, my lords, page 169. Rule 22, reservation, specifically provides, this has been completely, my lords, glossed over. Notwithstanding anything contained in these rules, vacancy shall be reserved for direct recruitment, absorption, page 169. and promotion in favor of candidates belonging to the scheduled castes and scheduled tribes and shall be filled up as prescribed in the ORV 75 and rules thereunder. Now, my lords, your lordship may kindly come to the ORV Act. ORV Act, my lords, your lordship may come to Section 12. Section 11. I'm sorry. Thank you. Section 11 first, my lords. 11A. এটা अच्छी बॉइटर दे दें कोर्ट को देगी तो लक्ष्य में kindly have this ORV Act 11A where promotion I'm sorry, Mark. Rightly, my friend is suggesting that I start with 10 first. Promotion based on seniority come fitness. 1. Where promotion is to be made on the basis of seniority subject to fitness, the scheduled caste and scheduled tribe officers shall be promoted to the next higher post or grade against reserved vacancies, provided they possess the minimum qualifications and experience required for such promotion. 2. Number of reserved vacancies.
What one says.
Mallards.
What you have read it one.
10.
10.
What does it say in your understanding?
Only promotion based on seniority.
10 says.
10 says.
Then 11.
Then Mallards 11. Where promotion is to be made on the basis of selection. This is another genre. This is another genre of Mallards promotions. Where promotion is to be made on the basis of selection, comma, the procedure for filling up of the reserved vacancy shall be as may be prescribed, and the number of reserved vacancies will be determined on the basis of reserve points shown in the roster maintained under Section 5. Under the ODRS rules, the promotion is to be based on selection. That is the basis. Then, Mallards 12. Selection from different services. Where selection is made from different services, the recruiting or appointing authority shall select scheduled caste and scheduled tribe candidates to the extent of the reserved quota, comma, provided such candidates satisfy the minimum conditions of suitability, qualifications, and experience laid down in respect of the post concerned. Then, my lordship may come to Rule 19, Section 19, overriding effect of this Act. Provisions of this Act shall have effect notwithstanding anything to the in any other law or any other rule, order or resolution made by the state government. Now, your lordship knows 16(4)(a), Article 16(4)(a) of the Constitution enabling. So, in order to grant that 82nd Amendment, the 77th Amendment granted that you could also grant to overcome Shani, that you could also grant reservation in promotion. That was 16(4)(a), simpliciter. Then that amendment to any other class or post or class or post, that comes in 82nd Amendment of the Constitution, my lords. 82nd Amendment, that gives that is how, my lord, that gives the retrospective seniority, and also, my lord, it widens the field that it can also create a class and grant, my lords, consequential seniority to the reserved candidates. So all this has to be done. Your lordship knows, my lord, and will appreciate that it has to be done by way of an enabling provision, which has to be done and has to be given the teeth and armed by way of a legislation. It can't be done by in a simpliciter, my lords, manner by law. So therefore, my lords, my submission before your lordship is this, my lords. Now your lordship may...
What is the fault with the judgment? The judgment appears to be consistent with the long line of rulings of the Supreme Court.
My lords,
unless your opponents dilute our view by their argument, as of now, we are not convinced. The judgment is in accordance with the decisions of the apex court.
My lord, your lordship may kindly see this judgment.
What is the fault line in the judgment?
Fault is, my lords.
Absolutely in accordance with the apex court judgment.
I'll tell you, Lordship. I'll tell you, Lordship, what's happened. In 2019, my lords, the petitioners before your lordship, the appellants before your lordships, there was a regular DPC held and they got promotion. And my lord, that was challenged, which was ultimately set aside. In 2020, there was a DPC. In 19 we got another DPC.
2019 itself.
Another second DPC was also in 2019, where my lords, juniors came in. And they're in position as on date. Then 2020, there was another DPC. Juniors was further, another set of juniors, they were promoted and they are also in position. 22, another set of juniors were promoted. Now at this stage, after working for 7-8 years, we'll be reverted below our juniors, at least 3 batches juniors who are already in position and who are all working. Now that would be one incongruity which will be unfair to us, one. Secondly, my lords, there are 40, for the present moment, my lords, there are 40 vacancies. There's an RTI document taken out by my learned friend. 40 vacancies there are.
When the other side can be accommodated.
Yes. Well, right now, till your lordship decides the issue, without reverting us for the time being, whether we can still continue, and without suffering the impact of the order for the time being, till the issue is decided. Because there is no pleasure in we being removed right now just to satisfy the opposite parties. Whether we can withstand, whether we can bypass the impact of the order for the time being, till your lordship decides the issue.
No, but there is no arguable point. As of now, you have not convinced us on any point.
Well, your lordship may kindly bear with me.
That point, reversion, that part.
That only the reversion part one, and secondly, it's a parallel bench, coordinate bench of your lordships have already stated that another judgment in the same light. In the same light, the ratio has been stated.
Identical matter.
Similar matters. Similar logic, similar reasoning, my lords. Your lordship has also referred to Lalit Naik's judgment in your lordship's order.
This is before which bench now? It will come before this bench only.
Yes.
It comes before this.
Before this bench. It should come before this bench.
We will call this matter along with the present matter.
And there's one more matter pending.
That Lalit Kumar Naik case which they have been referring to, there the judgment was with regard to work out a promotion policy. Here they have considered each and every individual cases. That the SC candidates were never considered for promotion. They were never into the zone of consideration. Forget special right. That point which they are raising, that is not. The issue was that they were never considered for promotion.
That is
valuable rights were taken away and injustice has been meted out to SC category right from 2019 onwards. And every year, what has been challenged?
Lordship's judgment covers the entire gamut of the case. And it is not a question of evaluation of merit. It is a question of reserving certain things for a general category.
But there is nothing like reserving something for a general category.
That concept itself is not there. If you are coming to zone of consideration by virtue of your seniority, then you are entitled to a consideration. Your merit can be evaluated with general category.
We will call this matter also together. We can decide both the matters together because there is some order now.
Only.
But the only thing is that because of the pendency of this case, they are not giving us promotion.
No, we'll fix it.
If they are promoted, we don't have any demands.
Take them on.
No, if we have promoted, which retrospective effect, we have no.
They say we cannot be disturbed.
Yes, that's big.
Having been appointed, promoted,
If they are, if we are giving retrospective effect of promotion,
they will be disturbed.
Well, the learned single judge gave them that option. They did not avail it. At that time also, they said, no, we want to argue on merits. Then he said that the consequences will be dire. You take your stand. If you want to rely that we are not to be promoted from retrospective effect, you please give up, tell your stand. They said, no, we want to contest. And the same plea which my learned friend is taking, that was earlier raised. So they have that. Now they give back upon and say,
We are before the Honorable Single.
So we
What I am
and what exchange took place.
may I say,
I'm relying my lord's judgment.
may I venture to suggest something? But they are telling that if we are giving promotion, they have no objection.
Provided their apple carts are not disturbed.
Yes, that.
So we are giving retrospective promotion from the date of their no otherwise giving seniority.
Even seniority. With one seniority means you are given promotion from that. We are not objecting that. We are only paying.
We should not be reverted.
the graduation list has to be redrawn up from the year 2009.
Our reversion may not be given effect to.
In my lord's judgment, that your lordship, there your lordship has granted the promotion without disturbing their promotion. And your lordship has granted the promotion from the date when they were promoted. That's my, I have given that copy.
With retrospective effect.
Yes,
But not disturbing already those who are.
The apple cart was never disturbed by your lordship.
So that is the only grievance before my lord. And I have seen that judgment. I also submit there is no fault with that judgment so far as merit is concerned. But only one part that in the during pendency of that wage petition, 3 DPCA, 3 promotions have been made. As we are promoted earlier, in the subsequent DPC we are not considered for promotion. And admitted fact, our juniors under UR category, they were promoted, now they are in a promotional post. And admitted fact, there are 40 vacancies in the rank of revenue inspector.
So what we can suggest.
How many vacancies are there?
After the 2019,
You are not permitting judges to speak at all.
My lords,
You are in the relay of arguments.
My lord.
One, second, third, fourth. There is no coherence at all.
my lord.
And the quality of arguments also is not that high. Quality is not that high. Anyway, suppose what I am suggesting is, because almost identical matter is being argued before the larger bench of the Supreme Court now. Almost identical.
This.
So what we are just thinking aloud is, whatever vacancies are now available, let the vacancies be filled up in a normative way without disturbing those who have already been promoted.
Yes, that's.
And we shall fix a date so that they also are not put to any prejudice.
Yes, ma'am. Yes.
I have a slight objection, my lord. Into this suggestion, my lords, I will only suggest that various writ petitions are pending in the High Court. Around 10 applications have been filed, wherein, my lord, perpetual illegality has been committed year after year. Because as if UR is a reserved category, they have proceeded on that notion and they have never considered and they have wrongly applied the principle of post-specific reservation, which was the moot question before this court following R. Nagraj case. So what has happened now, all these petitioners who belong to SC categories, they have challenged in the subsequent year. Now, if your lordship confines it, that the vacancies will be filled up, then their right also goes away without giving them any opportunity of hearing. They are now, all these writ petitions are sub judice before your lordship in the year 2022, 23, where whatever DPC has taken place, they have relied upon a circular relating to the year 2019. That circular was declared illegal by taking into consideration R.K. Sabarwal's case, Indra Sawhney's case, Saurav Kumar Yadav case, all cases were taken into consideration. They said that meritorious candidates in the SC category have to be considered under a unreserved category. That was the first point which was decided. Then the question comes whether total non-consideration is permissible or not. Now, by your lordship, in this judgment led by this honorable court, they have categorically held that no, it cannot be. So total non-consideration is not the case. So therefore, there is no error apparent on the face of the record. So whatever proposition, what they are submitting,
my lord, your lordship may consider it in this light, that subsequent repetitions are pending, because if all the posts are filled up, then their rights will be also affected. Taking into consideration that, your lordship may pass whatever.
Your lordship has, without discussion, your lordship, in your lordship's judgment, has categorically dealt with this problem to consider candidature as a promotion and grant such promotion with retrospective effect without
On the
monitoring.
date,
Sons monitoring.
the others were promoted without affecting their apple cart.
Yes.
If we agree with you, then there is a larger question which has remained unconsidered, maybe because the bar did not debate it in the light of Suburba, YK Suburba.
That
So-
arise for consideration in this case because UR cannot be a category.
It can never be the result.
Cannot be a
UR is never a category.
Never a category.
If that is the case, then at least the reserve candidates were in the gradation list senior and under the zone of consideration should have been considered. That is the only point. So Nagaraj and other things we are not seeing go into.
Nagaraj is from Karnataka.
The constitutional amendment was challenged, it was upheld. But they said that while upheld that
You want to say that they don't know this basic.
I don't know what my learned senior is focused at, but I would definitely differ in his contention with so far at what he is raising.
Heard that senior advocates, you are on caveat.
Caveat.
That senior advocates appearing for the appellants and representing the caveat. First, perused the appeal papers. First, matter requires a deeper consideration.
And now we decided in favor and covered it.
And therefore, the position held by the appellants herein needs to be protected without interdicting the filling up of party available vacancies. In a normative way. First now, in view of the above, first now, next paragraph. Learned advocates appearing for the appellants notified to us an interim order made by a coordinate bench of this court in a pending case in writ appeal number 2395 of 2024. Interim order dated 2011-2025, made in a pending writ appeal number 2395 of 2024. First one, they assert that the fact matrix of the said writ appeal nearly matches that of the appeal at our hands. And therefore, protection of the kind granted in the complete writ appeal needs to be extended to the appellant's hearing. Even this aspect also needs to be examined. And therefore, the writ appeal number 2395 of 2024 can also be taken up on the day when we are hearing the appeal at hand. First one. Next paragraph. When you were promoted?
19/1/2019.
19/1/2019. We are told at next one. We are told at the bar.
No, that is wrong.
Sorry. 19/1/2019.
19/1/2019.
11/12.
19/1/2019.
19/1/2019.
11, 12, others were promoted.
We are put in the
Including
bar
respondent. He was promoted on 11, 12, 2019.
that the appellants herein were promoted with effect from 19/1/20 2019, and therefore pending adjudication of the appeal, their position has to be protected. There is force in this submission. First, in the above circumstances, any other party, all are on caveat or notice has to go.
No, we have accepted, we are for caveat for some party. My learned senior is also appearing for one of the parties.
And any other parties are unrepresented.
No.
All are represented.
Yes.
No, some have been some state is appearing, other private parties notice has to go. If
Other private.
ARA kitchen also this one.
In the above circumstances, we make the following order. Issue emergent notice to OP numbers 1 and 2. First one. ASC Mr. Sen accepts notice, Ray accepts notice for the said OPs. OPs are respondents. What is respondents? First one. Notice, issue notice to the private respondents who have not entered caveat, returnable within 4 weeks. First one. Next paragraph. In the meanwhile, the impugned order judgment is hereby stayed, subject to the condition that such a stay shall not come in the way of the 40 existing vacancies being filled up in a normative way, subject to outcome of the appeal.
Where will be our cases will be affected.
From 2019, we have to.
2019 we have to be considered with a review DPC to be review DPC to be.
We cannot be equated to professors coming into.
We'll fix a short date. We'll dispose of appeals.
1 month is a long way. Already your lordship sees the date of the judgment and 2 days.
Next. For this appeal, along with the writ appeal number 2395 of 20.
Your lordship clarifies that there is no bar for holding the review DPC. Yes.
We also, before that, we also make it clear that we are not interdicting any review DPC if
as directed by the Honorable Single Judge.
As directed in the impugned judgment, provided that the apple cards of the appellants are not disturbed.
Yes. Great.
For the time being. For the time being.
But the date.
But appeal your lordship decided.
Other cases were to be
have to decide. We can't fix without service of the notice to rest of the people. Now you are also protected by some order. Yes. Up to notice. Service of notice. Therefore, we are not fixing the date. Yes.
Item 7.
Item 7, my lord. Lordship, may kindly take up the next week, my lord. I have served a copy of it to the cabinet, my lord.
2 weeks.
My lord, date. I am appearing for the caveat. Date. I want to solve a copy.
Call after 2 weeks at the request of learned ASC. Copy is given.
Not even in course of the day.
The copies of writ appeal shall be furnished to the caveations. Yes.
Item 8, my lord.
Yes.
It was filed by the Special Committee Ministry of Law. Now, Law Ministry has entrusted me to appear.
Yes.
And this name of Hon'Ble may be removed. Our name may be reflected in the card list.
Yes.
And I also remove the defects. Lot of defects are there.
Learned DS Chief, Mr. Paddy appears for the petitioners in the place of whom?
Mr. Honu Bhaskar is
Bhaskar, who has since
yes, he has challenged him and asked him to appear.
he suggests to be CGC.
He is not CG, he is senior Central Government Council for Union of India in Delhi.
Can you resolve?
I think they have written that the letter.
What is it?
Given a letter.
In the place of Hanu Bhaskar.
Senior Central Government Standing Council.
Senior Central Government Standing Council. First, registry to print the name accordingly. Yes. All after 2 weeks.
Next week.
Next week.
Next week because some
Any urgencies in what?
contempt has been filed. That's why. After 10 days, anyway.
Post this matter, immediately after office objections are removed. Okay.
Item 9.
Yes.
Item may short passover.
Passover.
Item 10. Item 10.
You are appearing in 10.
I am for the bank, opposite party bank.
He is not
We
here.
haven't, they haven't served a copy to us also.
Brother, you copy.
What password may be entered like that? Senior is coming.
Password. Yes. But you are not given the copy of the
Copies
petition at all.
haven't served on us.
You give copy to your friend. Password.
Lordship, in place, in cause list, the name of the advocate is wrongly written as Amrita Tripathi, which is wrongly written. My name is Ankita Tripathi.
Registry to printer. Ankita Tripathi in the place of Amrita Tripathi. Next week we will have this. Oh my God. Call next week.
Item 11.
We put the opposite party motion.
Your friend has not come.
Mr. Samir Kumar Misra appearing in this case. Item 11. Yes. Item 11, I was item 11, my lord. That
Not 10.
not 10, my lord. Item 11.
In 10 also, but in 10 only Amrita Tripathi appears. No,
This for opposite party.
Yes, sir.
Item
in 10, you, Mr. Mishra, you are
In 11, my lord.
11.
My lord.
10 call after next week to enable counsel for the petitioner to come and argue. Registry to printer. What's your name? They said
Ankita. Ankita
Tripathi in the place of Amrita.
Item 11.
Item 11. Petition for amendment has been filed because post facto the filing of the case subsequent event has happened.
What event?
That is relating to notice recalling the entire loan liability and directing for payment. That I want to bring on record by way of amendment. Copies have been given to my friend who appeared in advance.
Application in IA number so and so supported by an affidavit is right seeking leave of the review. Introduce what has been stated in the schedule to the amendment application on the ground that what has been so scheduled is a development that has happened in the recent past and therefore will have a bearing on the adjudication of the petition at hand. First off, with this proposal, very fairly, the concept representing the OPs also agrees. First off, amendment would not cause any prejudice to the other side. First off, rejection of the leave to amend would prejudice the appellate petitioner. First, next one, in the above circumstances, application having been favored, leave to amend has been accorded and accorded. First off, petitioner to file amended petition
By tomorrow, man.
tomorrow.
By day after tomorrow. Tomorrow is a holiday. Day after tomorrow.
First, after filing of immediately after filing of the amendment under the amended petition.
Man.
You copy and then
Yeah, I'll give it.
Item 12.
Item 12, I may permitted, my lords. 3 weeks time may be granted to comply the order dated 24/12, my lords. By which my lords, I was directed to get the order sheet of the DRT Cuttack, my lords, and bringing it on record, my lords. So 3 weeks time may be allowed, my lords.
2 weeks granted to comply with the order dated 24/12/2025. Failing which, on the next date of hearing, some adverse order may be passed.
Item 13. I have challenged, just with great respect to my senior, just I have challenged the order of the London Central Administrative Tribunal Cuttack Bench Cuttack under Annexure 1, that is the case relates to sexual assault harassed by a senior teacher to a grown-up girl of 17 years who was reading at that point I was 17 year and reading at 12th class. While imparting the private tuition in her residence, video, audio recorded and everything is there. And after due procedure of the under Article 81B of the KBS code, preliminary inquiry, summary inquiry, everything as per the Avinash Nagra case, all the documents provided with the so cause reply was given, personal hearing was given, and the termination order passed by the disciplinary authority, appeal filed, appear in person before the authority, and appellate authority confirmed the order of the disciplinary. Now the ground was taken by the tribunal.
Are you opponent or responsible?
I am the petitioner.
You are the petitioner.
I am the petitioner, madam. My senior is appearing for the cavator and I have copies served on
I have received a petition yesterday. Just a minute, let me press my case.
Sorry,
don't tell me. I am able to speak. Don't worry. I received it yesterday. I wanted 22 pages, treat minors. I must have gone through that.
That is the entire pleadings I have to file for worship. That is the entire pleadings.
At least a week's time must be.
No, I am not objecting that time. But because I filed on IA for stay operation of the terminal order, only I place your worship. That is the my pleading.
He agreed that on 21st that can be taken up. He told.
And on that day, your worship disposed of at the administrative stage.
That's the thing.
Yes, I have come with all the judgments.
On 21st, all this matter on 21st January.
Copy already served to my senior as a capital.
Next.
And another tribunal has taken.
We have granted that prayer immediately if you have not stated the entire story. Yes.
Item 40. That's problem.
Yes.
Item 14.
14. Nobody. Also, let us see. Sometimes the getting the matter posted is a difficult situation.
Item 15.
Same order. Pass over.
Item 16.
Yes, Mr.
There is a case where the bank, where I was the guarantor for the borrower. The bank had an outstanding loan of 2 crore 88 lakhs as on the date they gave the auction notice, the last auction notice.
2.88 crore.
2.88 crores.
You are the guarantor.
I'm the guarantor. And this auction has been going on from 2022. At least 20 attempts have been made, but not a single buyer has come forward. So on the last occasion, when they came forward with another auction of 37 lakhs, I gave the proposal at 50 lakhs. They said, no, you have to enhance it by another 5 lakhs, then we can consider. So we wrote a letter, we said that, okay, we are agreeable to pay 55 lakhs. Then they said, no, you have to include now the expenses and the charges, which is about 3.4 lakhs. So make it 58.4. We agreed. Then they rejected my application.
On the ground?
On the ground that, no, we are not satisfied with your application. I'll just show that.
Is for OTS.
Yes. Yes, only. Then they have now come forward with another advertisement where they have kept the base prices 27 lakhs 46,000 rupees.
What is the market value of the property?
Market value, my lord, I'm not to be very honest, because they have sold off a lot of properties also of mine also as the guarantor, and they have recovered about 1.82 lakhs, 82 crores, 1.85 crores.
What was the principal amount lent?
Lordship, we are appearing today we have instruction to appear for the bank opposite party number 1 and 2. Let them serve a copy, then after that we are.
I will, Lord. The only problem is the auction date that has been fixed to 16/1.
When have you
So
filed
they
the
should
petition?
not.
When have you filed the petition?
When we have filed on 8th of January. So it is on
When the
16th.
notice was issued?
No, notice has.
Auction notice was
Auction
issued.
notice was issued on 28/12/25.
And after so many days, if we come, we find it, we cannot halt the auction.
No, I'm not saying this should not confirm this sale at least. To that extent, if your lordships can.
No, not only that, if we make some interim order, the participants in the auction will be hesitant to participate.
My lord, the last,
Anyway,
I have filed an. Yes.
Anyway, on the same day, it is not being confirmed.
No.
There is a statutory period. So we will post this matter before the statutory period.
As your lordships.
Heard that senior advocate, Shri, when appearing of the petitioner guarantor, the subject loan, first appeal. He submits that the public auction of the security property is scheduled on 16/1/2026, and therefore the 6 and that let the scheduled auction go on subject to short of confirmation. First, learned panel counsel appearing for the bank submits that there is a statutory lull period for confirmation, and therefore the matter may be posted on any day before the expiry of the sale. First, proposal on both the sides is very fair. First, in the above circumstances, call this matter. When? Next week.
Next week.
Next week.
Which date will be suitable for?
What is the lull period? Under the rule for confirmation of the auctions?
I'm not aware of it, but
there is a lull period. I call this matter next week. We make it clear that the ongoing, the scheduled ongoing, the scheduled auction shall go on. The scheduled auction will go on.
Just to apprise your lordships of the failures of the attempted, I have filed an additional affidavit. I'll serve a copy on them also. As may be kept on record. Something.
You file it in the.
I'll file it in registry.
Yes, next.
Item 17.
My lord, this is for orders, my lord. The state has come up before the appeal against the order of the learned single judge. Well, delay of 251 days is there, my lord. And
what is matter on merits?
Merits, my lord.
Anything on merits?
Bypassing the finance department circular, that resolution, gadget notification, which specifically mandates that the DLRs engaged prior to 1993 should be given temporary status, and they should not be regularized. And that regulation was, that resolution was not challenged, and it was not even altered. And the Honorable Single Judge, on the basis of the finding that they were engaged prior to 1993 and with all regular appointment norms, so they should be regularized. My lord, our specific stand is the university sought for the government approval. The government did not accord that approval. Government rejection was challenged in the writ petition. The government rejection was on the premise that when the resolution is specifically clear on this subject, that the DLR NMRs were continuing, they should not be terminated. They should be continued with temporary status. That will prevail because the appointment norms, regulations and the rules as per Umadevi, which is still governing the field, that
How many years of service they have put in?
they have been put 1993. Since 1993, they are working. We are not terminating them. But the provision that ORV rules and the open advertisement, these factors were not there before that while they were appointed. So the illegal appointees should not be allowed to be regularized. On that principle only,
Not illegal appointees, irregular appointees.
my lord,
They will not be illegal appointees.
if the appointments were not in accordance with the rules and it was not open advertised, ORV rules are not followed, then the appointments, other persons were deprived to contest at their whims. The universities appointed them.
You appear for the OPs. Which OPs you appear?
No, respondents. I am appearing for
OPs.
all respondents.
I'm appearing on behalf of Dr. Purushottam Choli for respondent number 10 and 11.
They're proper.
Yes, ma'am.
Then it's vice
Vice Chancellor and university registrar.
Sir, short grievance of this bit.
Will condone delay.
Yes, sir. Sir, very.
Issue notice. Full stop. OP numbers 10 and 11 are represented by their panel counsel, Srimati.
Preeti Punyate.
So and so. First stop. The private respondents are represented by Shri. So and so. First stop. An application supported by an application in IR number so and so, supported by an affidavit is most seeking condonation of delay is grouped in filing the appeal. First one. Learned counsel for the learned AG appearing the appellant vehemently argues that there is an arguable case on merits and the delay being not too long, the same needs to be condoned. On the ground of cause shown. First one. Learned panel advocate appearing for the university and the learned counsel representing the private OP, the respondents do not much oppose the application. First one. In the above circumstances, application having been favored, delay of 251 days is condoned. First one. Call this matter.
51 days.
Yes, 51 days.
May I pray, my
week after next.
May I pray, my lord? Short grievance cannot be disposed of
today. Oh, because he says that there was no advertisement, nothing. When
yes, my lord. There is but they are by an advertisement, they are giving regularized. And the university has been regularized only for approval, they send it to the government.
Correct.
Only and some persons are.
Section. Which section of the Act, University Act requires approval of the government?
22. Can you peruse the annexer 7, page 19?
We do not peruse anything. We are asking a question to you. You are going to answer that.
That they can.
Well, week 22. Week after next. Week 22. How 22 is interpreted by various judges of this court. Bring those rulings. Then we will consider. It's advocacy. Yes.
My lord, we have filed an application seeking a stay operation of the.
Any contempt matter is put?
Contempt, my lord, right now I have no information.
Yes, when it is moved, we will take up this application for injury protection, which shall be taken up if there is any apprehension as to coercive action like contempt proceedings. Okay.
Exactly, I'm not having the figure, my lord, but some delay, we are admitting that delay. But this has come for appeal pursuant to the direction of the Honorable Supreme Court. Previously, challenging the order passed in the REIT application, we had preferred an appeal. But subsequently, we preferred a review. We withdrew that appeal, we pursued the review, and after that review, it went before the Supreme Court. Supreme Court said you preferred a REIT appeal. Therefore, we have come for REIT
What's
appeal.
the point of this?
Point is that Lordship must kindly have a glance at the peculiar page 2, cost title, page 2. Private respondent. We are against these private respondents who has been favored by the honorable single judge. That's Sitaram Dakua, working as junior clerk in Helen Keller Red Cross School for Deaf Amrupara. That the NGO active employee has been favored, that equated with the government employee. That is our stand. We have taken that ground. That while he is admittedly an NGO activist, NGO employee, and he cannot be treated at par with the government employees. That is our ground.
Why learned single judge treated him to be an employee of the state? What is the reasoning part in the judgment?
My lord.
In your objections.
Yes, my lord. My lord, I am for the OP number 1, my lord. I am from BC Barampur. And as per the annexure ABC, several identical cases already implemented, my lord. As per annexure C, the employee of the same school, 3 employees of same school, government implemented, my lord, as per annexure 3. And annexure A also, Bhubaneswar school implemented, deaf school implemented. Annexure D also, deaf school implemented. In my case,
One small for 2 boards. Otherwise, they will not do that. Yeah. Brother Panda.
My lord,
it appears you have implemented the similar orders.
That instruction, I have no facts in my
district.
Yeah. Annexure A to the counter epidemic.
Counter, my lord. To this REIT appeal will not.
That by finding the reply statement or the rejoinder as the case may be.
In the REIT petition, my lord.
No, counter A, they say.
Madam Sister, which is that document which said this is the 2000, this is Planned India?
yes, my lord, yes, as per annexure B and annexure C, annexure D also, they have implemented employee of the deaf school, my lord. As per annexure C, the employee of the same school, as per that of the petition.
Just hold, madam.
Where is it in respect of very same school?
It is in school.
Page 20 of the that is NSSC, page 20 of the counter affidavit, my lord.
Page 20.
Counter affidavit.
So they just in the school. Counter affidavit. Attendant, Helen Keller, right? Yes, it is in respect of the CHITTARANJAN, the Funda attendant.
Para 2, my lord. Order of para 2.
Yes, Mr. Panda.
Yes, madam.
Kindly come to page 20 and Annexure C.
Of REIT petition.
Yeah. You cannot be selective in challenge. You are state.
Annexure 6, my lord.
Annexure C. A, B, C, D.
A, B, C, page 20.
That counter affidavit.
Yeah.
Yeah. Annexure C is to the REIT petition.
No, it's not. It's not. Happening it.
So you can see it in the Wakam. Yes, someone to help.
They have implemented the learned single judge's order
That is
in
not,
respect of other matters.
that is not with me. That facts is not with me.
That's okay.
That is with them. Comes. There is nothing.
Para 2 speaks of the same school.
Whereas the petitioner, namely Sri
Kindly come to para 2.
Yes, my lord, I'm reading that. Namely, Sri Nilamath Dakwa, attendant school for the deaf Barampur Ganjam, Srimati Gitanjali attendant Helipel. Ganjam along with copy of the judgment passed by the to implement the claim. Whereas the representation of the petitioner along with the copy of the judgment passed to the court for the receipt to examined in detail.
State and its officials are preferring this intra-court appeal for calling in question a learned single judge's order. Okay. What is the date of the order?
The date of the order is
so,
when 29-1 June order.
Yes.
In June order is below 24/3/21.
2021, whereby respondents WP number 13882 of 2015 having been favored, the relief has been accorded in the following terms. Go to operative portion of the order. Next. Appeal is filed after brooking a long delay of how many days?
That 1,379 days.
1,379. If the application is moved seeking condonation thereof, first off, the said application is supported by an affidavit. First off, learned counsel, learned state counsel, learned AGA, Mr. Panda, draws attention of the court as to the checkered history of the litigation, in as much as the review petition was filed and thereafter appeal was filed and matter went to the apex court where a suggestion was given to press the review petition. First of all, the review petition having been rejected, the original order is put in intra-court appeal at our hands. First of all, though apparently delay appears to be too long, a plausible explanation has been filed for brooking the same, in brooking the same. First of all, this apart, it is an appeal by the state and therefore some laxity is understandable in matters like this. First of all, no objections are filed. Have you filed any objection to the application? Madam?
Petition objection, SLP not objected.
No, objection of the delay, condonation of delay.
Yes, objection delay to more than 6 months, my lord.
Have you filed objection?
No, filed, not filed.
Objections are filed to the said application. Right here. First, no prejudice will be caused to the other side should the delay be condoned. First, enormous delay may be caused if the same is not condoned. First, in view of that, we have allowed this application and thereby condoned the delay proved in filing the appeal. First, next paragraph. Learned, having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter in as much as put on exercise. Yes. The first contention of the contention of Mr. Panda that there is no vinculum juris of employer-employee between the appellant's hearing and the respondent is a bit difficult to countenance. First, this we say because of the other writ petitions and cases, namely WPC 12600 of 2020 and OJC number 10096 of 2001, etc., wherein the curriculum juries of the kind has been established and that the said judgments rendered in those cases, the judgments rendered in those cases have been duly implemented by the Commissioner cum Secretary to Government, while the order number 747 SSCPD dated 29/1/2021, a copy whereof awaits at Annexure C to the rejoinder, to the rejoinder of the respondents,
To the counter affidavit.
to the counter affidavit of the respondents. First off, therefore, the state cannot be selective in launching the legal battle against tiny persons like the respondents here. State being constitutionally ordained model employer, wide apex court decision in versus so and so. Next paragraph. For the ease of reference, the order of the Commissioner cum Secretary to Government dated 29/1/2021 and is reproduced in entirety. First off. Next paragraph. In the above circumstances, appeal being unworthy of merits is liable to be rejected, and accordingly it is, costs having been made easy. Next.
I am extremely sorry for that. I was not having the appeal records. That's why I was handicapped, my lord.
Correct.
I could have conceded to that extent if I had the records.
No issue. It happens. Yes.
Item 19.
Next.
Notice on OP 21 has a returned answer. Notice on OP 21 has not been served. I have to take press notice.
Appellants to take fresh notice in respect of unserved respondents.
21, only 21.
OP number 21. Respond number 21. Yes.
Item 20.
Well, this is also an appeal by the state.
Yes.
Where delay application is also there, my lord. Booking a delay.
Mr. Panda, your state government should have a separate limitation act saying that there shall be no limitation for filing of the appeal by the state and its officials. Anyway, how many days delay?
Delay of...
Short delay will condone the case.
Certainly.
Subject to government presenting a good book on law of limitation
yes.
To the association library, and also subject to condition that your officers will read one copy. This is report appeal is filed after booking a delay of 204 days in 204 days. First of an application in IN number also supported by affidavit in the appeal memo, wherein the explanation has been offered for looking at the delay. First of all, have you filed any objections?
Lord, here I entered caveat.
Have you filed objections to the IA?
Caveat get not served a copy will admit. For the first time this matter came before us.
We condone delay.
No, you will also condone the delay.
Intimate is concerned, we will hear you.
Lord, you will also condone the delay. Lord, I entered caveat.
We will serve
my
copy.
name is not appearing. And let them to serve a copy at least.
Yes.
So, if you agree, they will serve copy to you, on you. If you agree, we will condone delay.
Yes,
If you do not agree, we give time.
Lord, you will also condone the delay.
Learned counsel, you also have...
I have filed an intervention, my lord. I have filed an
intervention. Then let us. Learned counsel appearing for the respondents in all fairness submits that application be favored and delay be condoned. First off, ordered accordingly and application is allowed. Yes.
We may be copy of the appeal memo and all annexures.
That's a GA to serve copy of the appeal memo along with all the document on the counsel appearing for the respondents. First, your question arises only if I issue notice, not otherwise. Yes, next.
I got
2 weeks. 2 weeks.
Matter 41? In this matter below.
Yes.
On single judge order.
Why registry is not mentioning the number of delays in the court?
So giving it not giving there because they are giving to this family.
They are giving 557 days.
Yes.
Right, the office is given 556 days.
556 days.
556.
What is the explanation? No, Mr. Panda, we are not condoning this.
No, Lordship, kindly the explanation that it has come from the family court decree.
Family court is how many 1,000 kilometers away from the government?
So, my lord,
Which family court, how many kilometers?
paragraph 4, my lord.
No, rate appeal is against family court.
No, not family court. But that record shows, my lord, it has gone to the law department. It was there pending.
No,
in the law.
Pending there only.
And the law department given the opinion.
When it went to the law, when the order was made?
22. The rate appeal was for order, impugned order, my lord. Impugned order was made on, my lord, 16/1/2024.
16/1/24. When the copy was received?
Present case, the order was posted and the decision was taken on 17/6/20.
All that we do not know. When you obtained the certified copy?
Certified copy.
There is a direction to issue urgent certified copy of the order. You had applied 22 January you had applied for.
My lord.
And it is supplied on very next day.
Yes. After getting the certified copy, the process of filing commenced.
No, when how it stayed in law department for so many
law department and the chief secretary, that the additional chief engineer.
No, that makes no sense.
My lord, that's a table to table it had filed.
Table, they are not kilometers away.
Well, no, kilometers away, but impersonal mechanism that is.
Mr. Panda, in 2024 now, in 2023, you have the system of OJVAS. Now it is no more going from file to file.
Yes.
Desk to desk. It is coming in work-on.
But
so, and the responsibility is also fixed.
Multiple levels are there.
Even 1,000. In a day it is passing.
This is not a Keshwananda case, where opinion after opinion is sought for, etc. Something ununderstandable, inscrutable. We can understand. A simple matter.
Not simple matter. Widow has been favored with a family pension. A widow daughter who was staying in her parents' home.
Widow daughter dependent on the pensioner.
Yes.
He is entitled.
But the factual matrix is hazy. Factual matrix is hazy. Therefore, reasonable doubt was cast upon. And accordingly, she was given the opportunity to establish. And everything is there. Your Lordship may call for admission. It will be clear by your Lordship judgment only.
What are the grounds you have taken up? On merits?
Merits, my lord. First ground is that on the first date of hearing, the Honorable Single Judge has decided the matter.
No, have you taken up that we requested the single judge to give us time and he refused to give time? You have argued here. You have argued, in fact, all submissions are made.
No, Mr. Escobar, counsel appearing for the principal accountant general and a counsel appearing for the state party. It's hard. It was hard. But, my lord, it is a concession by the lawyer, my lord. The parties were never given opportunity. Parties should have been given one opportunity at least, my lord.
Where have you taken up that contention in your appeal memo?
In appeal memo, my lord, ground number B, capital B, page 6. Page 6. For that, the Honorable Single Judge, while passing the impugned order, disposed of the writ petition on 16/1/2024 at the stage of admission without affording any reasonable opportunity to the appellant state to file their counter affidavit justifying their action in not granting family pension to the respondent, which violates the principle of that ground we have taken. We could have exhausted our stand before the court. Thereafter, the reasonable order could have been passed, my lord.
Issue emergent notice. Return within 2 weeks. Yeah, both on petition, main matter and application. Yes, next.
Item 22.
In that matter, I have instruction to appear on behalf of accountant general.
This matter.
Oh. In 22.
21.
Shri. So panel appears, accepts notice for OP number, respondent number.
Respondent
general. All accountant general. Respondent number 2. Please give a copy of the pleadings and documents, Mr. Panda.
Yes, my lord.
To the panel.
Yes. Respondent number 2. Pro forma respondent number 2.
Response number 1. Reasonable within 2 to 4 weeks. Next.
Item 22.
My lord, in this case, my lord, still we are embarrassed by the delay, my lord. 712 days delay. I am so sorry, my lord.
What is on merits?
Merits, my lord. The last para of the impugned order, your lordship, may see page number 25. Page number 25, this para number 7. The learned court, Honorable Single Judge, my lord, exhaustively discussed the factual matrix on the first day without giving any opportunity to the state to file counter and imposed the state findings upon us, my lord. In view of such suggestion, the opposite parties are directed to consider regularization of the services of the petitioner and grant all consent. My lord, in view of such findings and position, then it becomes obligatory on the government, my lord. Government was not given any hearing or given any opportunity. The last para number, last but 2 paragraphs, 7 para. In view of such position, my lord. The government is agreed by this observation only, my lord.
But there is a direction to consider.
Yes, consider. But can we overcome these findings, my lord? That is the sole question. We cannot overcome, my lord, because in view of the such position, that is hindering at us, my lord.
No, in WP number 26860 of 2013, the learned judge has followed the judgment in 26860 of 2013. Is it your case that fact matrix of this case is different from that involved in the same WP?
Yes, we have got a different case.
No, where have you stated?
Yes, we have stated, my lord, in the grounds, my lord.
The fact matrix of that judgment is different, and the fact matrix of the writ petition is different, and therefore learned single judge could not have followed the said WP. Where is that contention?
Yes, I am just blessing it.
You had to find writ appeal also came to be dismissed. You had to find SLP also came to be dismissed.
My lord, it is.
Yeah, what in finally? No, unless you plead in your appeal, the facts of these writ petitions are different from facts of the cases stated, you have no case. Because whole judgment is structured based upon said decision. One sentence you show me, I will issue notice.
No, just give me one password. I'm not holding the right brief, my lord. That's the problem.
Item 23.
May I be your lordship?
Yes.
In this case, notice has been issued on limitation point below.
Yes.
There is 286 days delay to file this writ of inquiry.
You cannot.
The present petitioner, though party in single judge, no notice is issued against them. Now, one of the outsider in the stature filed a writ application as against the present petitioner as a PL petitioner as and now the present petitioner going to evict by the Tahsildar by virtue of eviction notice on the eviction notice miller. There the present petitioner is residing over the land since 1982 after to accept the land, homestead land in the plot miller.
On what basis you have gained entry to the land?
Well,
on what basis you gained entry to this land?
The present petitioner is a landless person as per the OPL Act Section 88. That land ought to be settled in their favor, Miller.
Ought to be, or it is settled.
No, not settled till now, Miller.
Have you made a claim?
Yes, they made a claim.
Where is that?
As per the co-op form notices, against them they filed a reply to show cause and stating all the facts, Miller. Now, one of the candidates opposed by one who has recently purchased the land 2020, now they made an allegation if the Tahsildar evict them, Miller. My submission is that in order to support the opposed by one, now the Tahsildar is notice to evict the 10% to the landless person, region at 82 million. My submission that, kindly see, the opposed party had no locus time to file the petition as against the petitioner over the government. Only government has the Tahsildar authority to issue notice, Miller.
No. Supreme Court has said,
yes, Miller.
Any member of the public,
yes, Miller,
can tell the government,
yes,
that particular public property is occupied unauthorizedly,
yes, Miller,
and therefore they should be able.
Yes, Miller. My solution is that now the opposed party one, he has purchased the land in front of his house, in front of the land. Now the present person residing. They have ingress and egress in their own land. They are not obstructive minor. Now,
your first contention falls to the ground.
No, that is the real case, Miller. Now the Tahsildar suppose want to demolish. Now this will rehabilitate them because they are landless more than less than 40 million.
They were issued notice and thereafter this order has been passed.
Yes, Miller.
You have been issued notice. You have submitted your explanation to that. Only thereafter this order came to be passed. What is wrong with the order?
No, without considering the reply to so cause filed by the present petition, they have issued notice, Miller.
Which representation?
You can receive your representation by the annexed 4 series, Miller, page 25.
25.
Yes.
You translate it to English.
25, 26.
Translate at least one page in English.
I am allowed to that. I have not translated in language.
No, you translate now.
Yes.
Your brother is also here, no?
Now the present petitioner, they are those who are the petitioner in this case, they are the appellant below. They made that allegation that they are residing since 1982. After the accept there are homestead land in plot in the 82 million. And they are residing over the plot number so and so, which is the case line in this case, Miller. And therefore, they have prayed that land should be recorded in their name since they are a landless person as per the government scheme under section 80 of the OPL Act.
Where is that?
You are claiming a land against your claim that you are a landless person. How can you insist upon the land which you are encroaching upon to be settled in your favor? Landless person can claim that wherever it is possible. That is a different claim. But here you are asking the place where you are encroaching upon to be settled in his favor.
As per the OPL Act 88, if the person has been residing more than 30 years, the statute has been given. Land ought to be should be recorded in their name.
Did you file the objection to this?
The petition are not noticed. The present appellant, though party is single, they are not noticed by the honor single judge. On the very day of admission, they let
go back to the notice that you received initially from the sub-regional magistrate.
The Tahsildar notice the order of the High Court.
Did you file objection to that or claim? Where is your claim?
My claim is that since the petitioner landless person, they are residing over the land.
Objection.
Yes, Will.
Under the particular act which you are now mentioning.
OPL Act. What is that? 88 Will.
You have to make a claim petition there.
Yes.
Where is your claim?
Where is your claim petition?
Is as per so was replied by the.
You are only repeating. We are repeating. You are repeating.
Yes,
and all sitting here.
Sir, my submission is that.
Now, where is your claim petition? how this scheme of the act is. Let us give that.
OPL Act Section 80.
Yes. Give that.
OPL Act Section 80.
No, you have to bring your book.
Sorry.
We will not give book to you. We have not taken oath to furnish our books to you.
Sorry.
Give the book.
My lord, I may be given an opportunity. That the order which is challenged in the writ appeal is not is at fault or any infirmity is there. It is order is totally innocuous in nature so far as the observation that in accordance with law, the matter has to be dealt with. So how he is prejudiced, I do not understand. If he has got
if you are going to evict him?
No, evict him, then this is a fresh cause of action. He can challenge it in another writ application or in contempt at least. But not in writ appeal. So far as writ appeal is there, my lord, there is no infirmity in the order.
My submission that Annexure 7, which is improved representational court, considering the limited grievance petition, the writ petition dispose the direction to the Tahsildar to proceed by virtue of this order. Now the Tahsildar issue eviction notice as against the present appellant.
And you have replied.
There is no reply.
You have not replied.
No.
You should reply to that notice.
Not with that.
No, why did you not reply?
Because
they have issued notice now.
Yes,
you should have sent reply to that.
Yes.
You have taken benefit of this order now.
Yes.
By virtue of this order, now the Honorable Tahsildar said that since Honorable High Court directed to not evict, but the early enclosure accordance with the law, with that observation, I issue eviction notice against the present appellant.
Yes.
My submission that since the present appellant a party with single judge, no notice is issued by the Honorable single judge. No notice is issued.
Tahsildar has issued notice to
Yes,
yes, you are not a party to this proceeding at all.
The party is Miller.
Before the learned single.
Yes, that is my ground. That is my ground.
All right.
That is my ground.
Now, go to para 3 of the order.
Yes, Miller.
It only says Tahsildar should take legal action against the encroachment.
In accordance with law.
In accordance with law. Agreed by this. Now Tahsildar has issued the notice.
Yes, Miller.
You give reply to that.
Yes, Miller.
This you were the petitioner.
No. I am the opposite party. 1 7 to 10. 7 to 10. What is it?
You are OP number?
7 to 10. 7 to 10.
You were not party, Vishwaranjan Nayak.
This was opposed party. As he filed a writ petition to evict the president.
Who were you in the writ petition?
I am opposite party.
OP number?
Opposite party.
Go to include order.
In the writ petition,
7 to 16.
OP number 7 to 16?
Yes, Miller. In writ petition.
This intra-court appeal is filed by OP numbers 7 to 16 in the writ petition. Number so and so seeks to call in question the final order dated 3/1/2025 made by a learned single judge of this court, whereby the following direction has been given. Police section. Next paragraph. Learned counsel for the appellant vehemently argues that his claims, being the encroachers of the subject land, have been peacefully residing in the same, with some having been put up
by the government. Government they Indira Avas over the sale land, government has granted Indira Avas independent person, present appellants.
Who has put the structures?
Present appellants.
That's what. That's it. Put therein, and therefore the writ petition would not have been allowed by order of the kind, at the instance of owner of a neighboring piece of land. First, he further submits that his clients are entitled to protection under that, which is that act. OPL Act. So and so. So and so. First one. Next one. Learned AGA, Mr. Panda, appearing for the
numbers 2 to 7.
Respondent numbers 2 to 7 opposes the petition appeal, stating that the impugned order is absolutely innocuous. 6. The Tahsildar, in terms of the impugned order, is has issued show cause notice to the appellant's hearing, and therefore it is open to the appellants to show cause against the proposed action by showing grounds, if any. First off, that being the position, he seeks a dismissal of the writ appeal. Next paragraph. Having heard learned counsel for the parties, having perused the appeal papers, we are broadly in agreement with the submission made on behalf of the official respondents represented by Mr. Panda, and therefore we decline indulgence in the matter. First one. Next paragraph. The operative portion of the order which has been reproduced above makes it abundantly clear that the jurisdictional Tahsildar has to take action, legal action against the encroachment strictly in accordance with law, and therefore whatever defenses are available to the appellant's hearing can be put forth before the Tahsildar himself. First one. Next point. On being asked whether the appellant's hearing have made any claim under the provisions of OPLA Act, so and so, the counsel for the appellant only reveals that they had filed their objections to the show cause notice issued by the Tahsildar, and beyond that, nothing is forthcoming from the records. First one. We are not sure that in the absence of taking up a formal proceeding under the provisions of the said Act, in terms of claim made by the encroachers, defense of the kind is the appellant's hearing. However, we don't want to deliberate more on this aspect of the matter, which lies in the domain of the Tahsildar. First, next paragraph. In the above instances, the appeal being unworthy of consideration is liable to be rejected, and accordingly it is. First off, however, the appellants are granted a period of 4 weeks for filing their objections to the Tahsildar's notice dated 15/10/2025 as a final chance. First, all contentions are kept open to be decided by the Tahsildar in accordance with law.
Extremely grateful.
No cost.
Till then, no course action.
Okay. That very the question. They have issued notice.
Yes, will.
Till a decision is taken on the reply to be submitted by the appellant's hearing, their occupation of the land in question shall not be disturbed.
Item 24? Item 22, the Passover matter, item 22, my lord.
Yes.
I have checked off. You have not, candidly, I confess that we have not taken that ground. Lordship may kindly grant one opportunity to seek amendment and to insert that.
Yes.
Item 24?
Item 24. Appeal by the state.
Now, what is the matter?
Matter, my lord.
Delay is 250 days. 349 days. Let the officer pay 3,490 rupees to him. Yes. We'll cut down the delay. All right?
Yes.
This intra-court appeal is filed after booking a long delay of 349 days. First off, an application in IR number so and so supported by an affidavit moved seeking its condonation. First off, though some plausible explanation is offered for condonation of delay, application of the same cannot be allowed unconditionally, argues counsel representing the OP, respondent, yes, representing the respondent, and we agree with Mercy. First off, in the above circumstances, application having been favored, delay is condoned subject to the which appellant should pay. First up, which appellant will pay? We'll make him subject to appellant number
by the government, because
this is government only. That to you. Which government? Which?
Appellant number 2, Milord.
Number 2.
Appellant number 2.
Appellant number 2, paying a sum of rupees 3,490 within 2 weeks. To which respondent?
But I am representing all. All are the same, only one prayer, my lord.
To the counsel for the respondent, my lord.
To the counsel for the respondent.
My lord, that within 3 weeks.
Counsel for the respondent.
Lordship must say within 3 weeks.
Within 3 weeks. Failing which, failing which the application shall be deemed to be rejected, and as a consequence, appeal also stands accordingly rejected.
My lord, will serve copy on the appeal memo.
Yes, you give that copy to your friend along with the amount.
Yes.
Item 25.
What I will do is, will condone delay, will call this matter next week.
Yes.
To bring DD. Otherwise, that will never come.
No, definitely come. I will ensure that. I will definitely. My lord, that 22 item, my lord.
22, 2 weeks we have given, na? You wanted to make an application.
Great.
Yes.
Item 25.
Maybe you know,
yes, sir.
Well, petition had challenged a regulation introduced by Orissa Electricity Regulatory Commission.
Regulatory Commission.
Orissa Electricity Regulatory Commission. They have power to issue regulations, notification time to time to regulate electricity purchase, sale, distribution of electricity in the state. So they have issued a particular regulation that's called OERC, the Renewable and Co-Generation Purchase Obligation and its Compliance Regulation 2010. What is this Renewable Co-Generation Purchase Obligation? Suppose I have a power plant or I have a distribution company. I am purchasing from some power plant which is generating electricity, by using conventional energy, means fossil fuel.
Conventional energy.
Conventional energy, fossil fuel means like coal. So to encourage non-conventional way of generating electricity, that is renewable source of energy, biomass, solar. To encourage all that, a burden has been given, fixed, on the people, those who have plants, companies, power plants, captive power plants. A burden has been fixed on them that a particular percentage of their generation, their consumption, they are bound to purchase from non-conventional sources.
Repeat.
Let's suppose I have a captive power plant.
Of non-conventional,
conventional. Suppose the captive power plant made on. I need it for my industry.
You consume X amount of energy.
I consume X amount of energy which I generate in my plant by using conventional energy like coal.
Okay.
It has some impact on the environment. Purpose is, it has some purpose. Environment. That's why government under the National Electricity Policy is encouraging generation of
non-conventional energy production.
Non-conventional. To encourage that, a burden has been fixed on the persons, those who have
captive consumers.
Captive consumers, the captive power plants
that they have to purchase a quantum, particular percentage of their consumption from non-conventional to encourage them. So ultimately, in a cycle, it will have some impact on the environment. That is the long term, because of the global warming, whatever we call it mirrors. So this particular regulation has been challenged here.
What it says?
This says,
which part of the regulation in a herd seat?
No, I am challenging the entire
regulation.
In the sense that this regulation, I have a particular plant, millards. My claim is, suppose I have 25 megawatt of power plant. Only 5 megawatt I generate using conventional energy. That is conventional fuel, that's coal. Rest all 25, I generate by non-conventional method. For example, by collecting the heat that is supposed to go from a plant to the environment, I restrict that heat, put it through boilers, and generate. One is heat, one is steam.
If the heat is
I'll just clarify this. So I have three sources. One is heat. Then 2 turbines I have. Steam. The steam that is generated also from my plant, that also convert energy. So I say I am a co-generational plant as per the definition. So this burden is not applicable to me.
If it is not applicable to you, why are you challenging this?
They have made it applicable to us. We are challenging the power of OERC to bring plants like us
within
the fold of that. So that's why we have challenged the regulation. In fact, a batch of 4 or 5 writ petitions so that they are along with this. In all intimators are passed, in all notices issued, pleadings have been complete. And
those petitions,
I think some of them have been withdrawn.
Some of them withdrawn.
Yes, some of them withdrawn.
Pending.
I am appearing for Orissa Renewable Energy.
Very well. Now you concede that they have power to make regulation. Your challenge is
that is also one of the grounds.
This power they do not have.
They also don't have this under 86(1).
Other than that, they could have made.
Otherwise, they could have made. That is the point, actually. So anyway, pleadings have been completed. OERC is supposed to be a party, they are not there today.
It's the main party because notification is there.
Issued by OERC.
My client, OPIT number 2, is the nodal agency to implement the OERC's regulation.
Therefore, who is the author of the regulation?
OERC.
Are they notified now?
No, they were there. They were appearing before. Now they are not there.
Mr. Pagari, one more query.
Yes.
In order to have your non-conventional method of going for the electricity, generation and electricity, do you require to have any kind of permission from OERC before that, so that they could know that you are also engaged in the non-conventional method of?
They have to have permission under the
It's a very important question, Lovers. When Electricity Act 2003 came, Lords, correct. No license is required, no permission required to set up. But since our hours also is calculated for the grid of the state, OERC has a detailed information regarding our source of generation. They have.
But one judgment of
Yes, that is Hindustan Zinc versus electricity. That is a very important judgment. In CPM, that judgment, entire regulation was upheld and the matter was hard at length. Lordship can see the last line of the judgment.
This contention is treated.
Yes, it was a similar judgment. And that's why 4 to 5 repression withdrawn. And in fact, that was also rectified by this also OERC. This is the judgment.
What is your contention?
This is regulation.
I have to see the judgment.
What? Just look into that judgment.
Yeah, we just look at the judgment.
Share a copy of that.
And also the angle from which we have challenged the regulation, that will satisfy the court. Also the fact, even if the regulation is valid, I am out of the purview of the regulation.
You are out of the court because Justice Rajendra Babu, Chief Justice Rajendra Babu bench held, if a piece of delegated legislation's constitutional validity is upheld on XYZ grounds, subsequent challenge to the same on alpha, beta, gamma grounds is not permissible. Therefore,
Logic is
since the highest court of the country finds a piece of deputed legislation as constitutionally valid, then you can't say this ground was not argued, that ground was not argued, that is not available. But if any coordinate bench has said, it is available to you. But if the highest court of the country has said,
it's final. It's final.
it's fine.
It's final. It's fine.
Therefore,
That is reported in 2015 for Supreme 711.
for Supreme 711.
7.
Just look into that judgment. If you have another copy, give it to him. Nihal, no.
I know about that.
My Lord, and in fact, he knows.
Notes ಮಾಡಿ. No, short notes ಮಾಡಿ.
We'll give it in February sometime.
Following this judgment, Karnataka High Court also had rendered a judgment.
Yes.
Just look into that. Justice R. Devdas and another companion judge.
Hindustan Zinc's matter was also referred to in that judgment, Karnataka judgment also.
Okay. I vaguely remember. Just look into that.
Sometime in February, first week of February or something.
The pleading completed anytime.
Pleading completed. ORC has to be there. So
who appears for the
ORC? Who is the person?
Swine.
Name is shown.
Yeah. What's his name?
Yes.
So we'll see.
Solve this matter and give a date in the first week.
A Das is many. A Das.
No, I'll charge you.
My lord, I am for the government. OP number 34.
Mr. Panda,
3 and 4.
appears for 3 and 4.
Yes.
3 and 4.
I am for OP number 2.
Okay, that's appears for
Satyakam.
OP number 4.
OP number 2.
OP number 2.
Satyakam.
Then
This
who
is
other-
Mr. Satyakam, my lord. ORC repeated Mr. Satyakam. Mr. Satyakam.
appears for ORC is OP number?
OP number 2.
OP number 2.
Oh, sorry, ORC OP number 1.
1.
Oreda is 2. Oreda is 2.
My client is OP number 2.
Okay.
Judgment.
This petition is filed in 2015 when law was not settled.
Yeah.
Now law appears to be
Yes,
settled.
ma'am.
Just
Yes,
look
yes.
into
Yes.
and come.
We are squarely covered, my lord. But
Let us see. Just to read it.
No. My lord, I friend knows also.
Special notice item 1.
May I please your lordship? This is regarding Miller's no confidence
When
motion.
no confidence
Gram
this was
Panchayat.
issued.
Gram Panchayat matter, Miller. Your lordship in full bench has decided whether the provision is mandatory
We
or
held that
harmonious instruction can be given.
We held it mandatory.
Mandatory.
Correct.
Here, Miller. But those decisions there. Full bench.
Anyway, I know that because I am the author of that judgment. Yes.
Now, Millard, after that, in our case, Millard, I have given a date chart. And I also annexed the Oriya Annexure 3.
Date chart?
Oriya Annexure 3 in English. That is the include in this one.
Sarpanch is voted by the constituency.
Directly elected.
Directly elected.
And here, Milord, that point only elected Sarpanch was resigned, Milord. In each place, the Naib Sarpanch was asked to take charge of the Sarpanch. That is Annexure 1. I have given the that English translation also.
No confidence resolution is passed on 15-7.
15-7.
Requisition to the sub-collector for no confidence. The no confidence motion procedure.
That is 24 seconds.
No, I have not completed my question. I meant to complete. The procedure prescribed by the Act.
No.
That is 24(2).
24(2).
Is applicable to Naib Sarpanch also. But Naib Sarpanch is not elected directly from the voters.
No.
He is elected from the elected members.
Members. After resignation of the elected Sarpanch, the present petitioner was in charge of the Sarpanch, Milord. There is no disputed fact, sir. And while Milord continuing, a requisition was made by the members for no confidence. And that was, Milord, sent to the sub-collector. Sub-collector has issued notice to conduct a meeting. While sending that requisition, only requisition was sent, the resolution was not sent.
That is the case.
That is the case.
What the learned single judge said on that? What the learned single judge said?
Learned single judge said, Milord, after taking note of the judgment, the larger bench decision and other things, because the notice was physically served on the petitioner, the technicalities will not, the Act, other technicalities is not applicable.
That notice is served on him.
Served on. In person.
Correct.
But Milord, your lordship kindly see, section 24(2)
says that it should be accompanied by
resolution
and note. But notice is served on him.
Notice without resolution. Notice was sent without resolution. Annexure 3, Milord, that is impugned. Your lordship, the English translation I have given along with the date chart. Along with the date chart, last flag, Milord, your lordship given. That is the point. Whether the mandatory provision required in 42, as 24(2) and as other subsection, that says, clearly says, requisition along with the resolution. Here only requisition was sent. Resolution was not enclosed. That is the challenge before your lordship. Your lordship also in full bench answered that question.
Yeah, I know that. I am the author of that judgment.
Yes, that has to be enclosed along with the resolution. That Milord, Learned single judge said, subsequently, Milord, after challenge, subsequently they have developed the things by way of affidavit, they have, Milord, explained things. So my contention is that whatever is there in the Annexure 3, that is to be complied. Any further explanation by way of affidavit not permissible. That is in view of the judgment of this Hon'Ble Court. In a tender matter, Milord.
That was pursuant to 78 Supreme Court, Mohinder Singh Gill.
Yes, that is delayed upon. How is the Supreme Court judgments are relayed? Paragraph 7.
Which is that judgment? Is it Mohinder Singh Gill?
Mohinder Singh, it is our High Court judgment relying upon Mohinder Singh and other judgments of Supreme Court. Paragraph 7.
There are only two judgments. One is
I will tell them that is
AR 1952 Supreme Court page 16.
Yes.
Write down.
Yes, page 16. And Commissioner of Police, Bombay, that is page
Correct.
16.
Versus
And-
Govardhana Das Bhanje.
Yes. Yes.
Correct. Another one is Boinder Singh Gill versus Chief Election Commissioner.
That is Milad 78.
Court 851.
851.
Correct.
And the other decision, Milad, 2008 4 Supreme Court 144. Those are the decisions. Yes, those are the decisions relied by this honorable court in tender matter.
That is for, that was on the proposition, if a statutory authority makes an order, its validity has to be adjudged on the basis of the reasons given in the order itself.
No explanation
not be supplemented.
By
that proposition.
That is the proposition I am taking here, Milad. Aid. I am taking aid of that. Annexure 3 English translation, your lordship kindly see. That along with the note I have given.
No, I want to know the observation of the judge.
Observation of goes in your lordship kindly see page.
Para 6 of the.
Let me. That is Milad, page 18. Of the judgment, para 6.
That is what is it?
Judgment Miller, annexure 4, starts from page 14. And the relevant portion I wanted, Miller, page 18, para 6, at page 19, from the top, 6th line. Para 6 I will place here.
Now, learned single judge says the notice has been served on the petitioner, your client, accompanied with the resolution and requisition. Is it true or not?
No, that is Annexure 3, there is no resolution included. Only requisition that is mentioned.
Note is also referring to Annexure B by 5.
Yes,
which so
that is what I say. It is subsequent developments, counter, and the counter they have introduced all these things. When the notice was given, no confidence motion notice, that is to be enclosed along with the resolution. Annexure 3 very clearly shows it is only requisition. This requisition was not given, not resolution. That is to be taken into account. That is the one question, Miller. Second, the election cannot be, this no confidence motion is to be held after 2 years from the date of assumption of 24/4.
Yes.
That also court has said that no answer is given. Even
what is the period now?
The period is 2 years not completed.
1 second. No confidence motion can be moved before the expiry of 2 years from assumption of office. When you assumed office.
My office, I am Annexure 1. That is 12/6/2024. No, Miller, date chart, item 4.
No.
12/6/2020.
That is only in charge.
In charge.
An in charge person does not hold the office.
Yes.
Because of the judgment of Apex Court followed by Karnataka High Court.
Yes.
In Karnataka High Court, take out that judgment. Basavaraj Dhotrad versus Basavaraj N. Dhotrad versus Board of Directors, so and so. Justice Nazir's judgment. Removal is not from the office of the Sarpanch.
Yes.
It is from the office of Naib Sarpanch.
No, here my lord, Sarpanch was, elected Sarpanch was resigned.
Correct.
And in his place, the authorities appointed this Naib Sarpanch to take charge of Sarpanch. Section says 24(4), your lordship kindly see, the language of section 4.
24(4).
24(4).
Take out that judgment. Please read.
Yes.
Yes. 24.
24(4), million.
4.
Without prejudice to the provisions of subsection 3, no requisition under subsection 2.
No, not that. We want to know that your client was appointed as the Sarpanch.
In charge.
Not in charge.
Therefore,
you are saying
in charge is not appointment.
Yes, not appointment. He was.
Therefore, removal is from the office of Naib Sarpanch. When he assumed the office of Naib Sarpanch.
Naib Sarpanch.
This assumes importance because the reckoning period of 2 years. Reckoning period of 2 years has to be from the day he was elected to the office of Naib Sarpanch. Because of Dotra.
That is prior to that. That is.
Then the ground goes. You are operating on a wrong legal and factual premise that the resolution is for the removal of Sarpanch.
Yes.
It is not for the removal of Sarpanch because office of the Sarpanch is vacant after the Sarpanch vacated the office by resignation.
That is immediate.
Nobody is appointed to that. Nobody can be appointed because office has to be filled up by election from the constituency.
Yes, Miller. That is Annexure 1. Order is there till new Sarpanch was elected.
That is in charge.
That is in charge.
Removal is for. Resolution is what?
Resolution is, Miller, that he was not resolution. By order, that is annexure, that is.
He was placed in charge is already. We have understood all that. We are traveling still faster than you. Go to the resolution passed by the no confidence resolution proposal, which is that proposal. That's called proposal into the act.
25(8) to
That is Miller 12/6/2000.
12/6/2000.
Notice
25/8/2020.
25(8). An extra 2.
25/20 order directing the to decide what the
no. But this is not. Proposal, where is the proposal?
Where is the
No, it is only requisition.
When was your client appointed as the Naib Sarpanch?
That is Miller 12/6/2024.
So when the resolution was moved?
Resolution was
moved
2025.
Proposal was
25/8/2025.
25(8)
25/8.
25(8)
Whether a 2-year period applies to Naib Sarpanch also?
Yes.
20. Which is that moratorium period? Which is that section?
21/2
is your appointment as in charge.
21/2 is irrelevant. 24 speaks of vote of no confidence against Sarpanch or Naib Sarpanch. Where at a meeting
Suppose Gram Panchayat election held in the year 2022, my lord. Gram Panchayat election held in the year 2022, my lord.
Then it is that ground is not available.
Yes,
it is more than 2 years.
More than 2 years and a half year. 2 and 6 months. 2 years and 6 months, my lord. That period. 24/4, my lord. And
when the election took place, brother?
Election, my lord, exact date 2022, my lord. February 2022.
No. Election.
Let's see.
Gram Panchayat was constituted. Okay?
Yes, Madam.
With the Sarpanch and elected members. These elected members elected the Naib Sarpanch. When it was?
That is
That is the correct date.
22 to 2022, first. The Grand Panchayat election Odisha was conducted. Grand Panchayat election result was declared. Sri Umacharan Malik is declared Sarpanch. It is 3/3/2022, same day.
3/3/2022.
Election conducted 2022. 3/3/2002, Gram Panchayat election result was declared. And Sri Umacharan Malik, that Sarpanch, he was declared as Sarpanch. So he has resigned on 10/6/2024.
Not the point. You are not answering my point, sir. When your client was elected by the elected members of Gram Panchayat as Naib Sarpanch, when that date?
That is Millard 2022 to 2022. All that is the results published. And from the date of result 3/3/2022.
That is the
3/3/2022 is the result of general election to Gram Panchayat in the whole state.
Yes.
Correct?
Yes.
Gram Panchayat was constituted. When the first meeting of the Gram Panchayat took place, in that meeting, Naib Sarpanch is elected. When that election was meeting took place.
That information is not.
Then cannot be done. Then first ground dies. First ground of 2-year moratorium dies.
That 24/4.
Goes.
That Millard. Now the only question is, now this no confidence requisition. 3, Annex 3.
But whether you have received a copy of the resolution?
I have received only requisition, not resolution.
That is the requisition which the officer has sent to you. Correct?
Yes.
Pursuant to the proposal of the Gram Panchayat members.
Yes.
But in the meanwhile, you were served with the copy of the resolution and copy of the notice.
Copy of the notice, Millard, Your Lordship, kindly, I want to. Millard.
We are asking a question.
Yes, I have answered
that.
Subsequently,
Then you can build the law.
Millard, subsequently, Millard, that was clarified by in a counter. They have given an annexure saying that Gram Panchayat, this requisition and resolution is served on them.
Yes, whether you bears your signature.
Acknowledgement due or
Acknowledgement, no.
No, but that says you have signed and accepted it.
That subsequently, by way of counter, they have given, but that they have not denied the Annexure 3 that it is given with the requisition. They have not said.
With not also.
Yes. In affidavit also, counter also, they have not said. They have not disputed that point. They cannot develop it by way of counter, so many things.
No,
but first, Millard, that notice was Annexure 3. They have given to me. There no.
You have said it about half a dozen times now.
Yes.
And Millard, there are
going further.
Yes, further, Millard, I have said, very specifically said in my writ application, even in the counter and rejoinder also, they have not served me the resolution. Counter they have filed. To the counter I have filed rejoinder. There also I have said that no resolution served on me.
But why the learned single judge says that all they have been served on you? Kindly come to para 6 of the impugned order.
Yes.
Must I be thinking to make a point? That's not good. Para 6.
Yes, para 6.
About 8 lines below.
Yes.
In fact, the plea of petitioner is that there has been no service of resolution requisition along with the impugned notice, Annexure 3. Yes. But on a bare perusal of Annexure B5 to the counter affidavit, it is made to reveal that copies of the resolution and requisition have been sent along with the same day and duly received by the petitioner.
This is subsequently they have said in the counter, saying that to that I have given a rejoinder. I have not received the resolution. My rejoinder, Your Lordship, kindly see.
All right. Sure. Let the rejection go on. Rejection not be announced. the no confidence motion meeting be held tomorrow, but the result will be kept in sealed cover.
No, that is now kept in sealed cover.
Let it be kept in sealed cover. But now it is dismissed. No? Now it is dismissed. Petition is dismissed now. Election was, the no confidence motion took place.
Not counted. Not counted. Oh, that's not counted. That is kept as it is.
Direction of this one.
Stay, there was a stay of the by this honorable.
You had to stay. You should accept notice and produce records before us. We'll just ascertain whether you are served with that, along with notice, rejoin the resolution and notice. Both they should accompany the statutory notice if the law declared by the full bench. But he says the resolution was, copy of resolution was not accompanied. Therefore, we want to ascertain only that fact.
Yes, that is if resolution they have served on me, there is no case.
Issue emergent notice. Learned CAC Mr. Ray is requested to accept notice for 1, 2, 3, 4. For Panchayat also he will receive.
Yes, he will receive.
For all, madam.
All 5 million. No private parties.
No private party.
First off, an application in I number so and so supported by affidavit is moved, seeking interim protection. First off, that counsel appearing for the petitioner's appellant submits that in the provisions of section 24 of Odisha Gram Panchayat Act 1964 are held to be mandatory by the full bench judgment in so and so. Full bench judgment in Navanita Kappat Patra versus Collector Tandamal and another writ appeal number 1367 of 2025 is poured off on 12 and 29 11 2025. First off, he disputes the finding of the learned single judge that the statutory notice issued by the authority was accompanied by resolution and the notice as well. First off, this fact needs to be ascertained since it goes to the root of the matter, and thus the case is made out for issuance of interim protection as sought for in the application. First off, in the above circumstance, application having been favored, the interim order granted by the learned single judge during the pendency of the petition would continue till next date of hearing. For this matter on 3/2/2020.
Lordship, that interim order has been vacated in 16/12/2025.
16/12/25. Final order has not been passed.
Final order I have.
But in the agreement, it is mentioned in other
Lordship order itself is Lordship interim order dated when it was granted to you.
September 2025. And ballot
23/9/2025.
Lordship, ballot the honorable single judge vacated the same.
Yes. Therefore, we are continuing it. Yes.
But meanwhile, near about 1 month has been passed.
Let us.
Might. If result has not been published, Lordship may say.
Result is not published, na?
If not published, I have not taken any.
However,
today
the result of the no confidence motion is already published. This interim order, this interim protection will not inure to the benefit of the appellant.
Then certificate copy.
Today you will get it. Yeah.
My information is not declared. Not yet declared.
We do not know. Therefore, we have to put an if there. Next. Yes, come.
Item 3.
Yes, what is this matter?
My Lord, petitioner challenged the order by annexure 8, my Lord. The fact of the case, my Lord, the petitioner is the second wife of a school teacher.
Second wife?
My lord.
When the marriage took place?
When the marriage took place in the early 60s, my lord.
First marriage took place when?
First marriage is, I am the second wife. First marriage, I have don't have any knowledge.
Anyway,
As the first.
Your client's marriage is subsequent to first marriage.
Yes, my lord. Yes, ma'am.
So it is no marriage in the eye of law.
My lord, I am coming to that, my lord. As the first wife has not has any issue, he marries the second, the present petitioner. And this fact is also communicated to the authority, school authority, and it is reflected in his pension books. And the first wife has also got the family pension after the death of the husband. And after the death of first wife, my lord, present petitioner approached the authority for family pension, and the authority rejected the claim of the petitioner by Annexure 6 at
On the
best.
ground that your marriage is not valid in the eye of law.
No, on the ground that the notes below the clause D of sub rule 6 of rules 56 of OCS pension rules.
What it says?
My lord.
To seek family pension,
yes, ma'am.
She should be a widow.
Ma'am.
Widow presupposes the status of a spouse.
Ma'am.
Your client cannot be a spouse because when the marriage was contracted, already there was a subsisting marriage.
Ma'am.
Therefore, the status of your client is, we do not use any other word like concubine, etc. It is certainly not of a spouse. Number one. Except under section 16 of the Hindu Marriage Act, there is no legitimacy granted to the second wife on the death of first wife. Merely because the first wife subsequently dies, the status of spouse is not attained by your client. That is the law.
Yeah. Lord, in that effect, one judgment is coming to my knowledge, my lord.
Yes.
If my lord will permit me,
yes, you give that.
I will
give that judgment. There is a Duncan C. Derrick, a famous author on Hindu law, whom mains Hindu law refers to. He has said like this, and it is affirmed by the Supreme Court. What it says?
My lord, it says, my lord, when one person is staying as the husband and wife for a quite long period, as per Evidence Act 114, my lord, that cannot be, the court cannot presume that is not legal, valid marriage, and it is also a pension matter.
But in that case, first wife was there?
Yes.
First wife was also there?
Yes.
No, we will agree with this. We'll overrule this. It will be a havoc. Pension, family pension is payable only to the widow or widower sometimes of that government service. It cannot be given to anybody else. First wife is dead and gone. And therefore the second wife should be given. Where is the provision?
My lord, this rule says that, my lord, wife and wives.
Wife and wives means where personal law permits contracting of multiple marriages. Your client is a Hindu.
Yes, ma'am.
He cannot marry, he is not Sri Krishna. He cannot contract 16,000 wives.
My lord, that is true, my lord. But as per this judgment, my lord, as I have come.
No, we don't subscribe to that.
My lord, it has been relied upon many judgments of the apex also. And I am, my lord, this pension rule is a beneficial legislation. And when they says that wife and wives, and also stated that after the death of the first wife, second wife will get the pension.
Provided there is second wife. There is no second wife at all. There should be second, for example, in Mohammedan law, by Mullah, Faizi, etc. A Muslim is entitled to marry, contract more than one wife. Up to 4. He can divorce the 5th one, 3rd one, and marry one more. That is personal law. But amongst Hindus, monogamy, which Lord Sri Rama followed, is the law, not what Lord Krishna did. Therefore, this Krishna cannot agree with your view. Right now.
Look, kindly have a glance to that judgment, my lord.
Nothing like
Well, it is also
this intra-court appeal calls in question a learned single judge's order dated so and so, whereby appellant's WP number so and so has WPC number 3822 of 2022 has been negative. First off, in the said writ petition, the appellant had called in question the order dated 12/11/2021 passed by the OP number 4, whereby her claim for family pension was negative. First off, learned counsel appearing for the appellant vehemently argues that the pension rules specifically employ the expression wife or wives, and therefore her client being the second wife of the deceased employee, the first wife also having kicked the bucket, is entitled to family pension. First, learned ASC appearing for the OP opposes the petition, making submission in justification of the impugned order and the reasons on which it has been structured. First, in support of her claim, learned counsel for the petitioner presses into service the judgment of Apex Court in Srimati Sri Rambai, wife of Hon'Ble Bhave versus the Captain Record Officer so and so, 2023 INAC 744. First, having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge. First, amongst Hindus, after the 1955, the Hindu Marriage Act came into force in 1950. Hindu marriage, after the advent of Hindu Marriage Act, enactment of Hindu Marriage Act 1955, amongst the Hindus, monogamy is the thumb rule with no exception whatsoever. First one. Therefore, the idea of very second marriage during the subsistence of the first one abhors the pith and substance of this act. First off, however, a limited legitimacy is contemplated on the progeny of the second marriage by virtue of section 16 of the said act. First off, however, the extension of that legitimacy to the case of the appellant is not permissible. First off, next paragraph. The vehement reliance of the counsel on the Apex Court decision in Sri Ramabai does not come to the aid of her client, in as much as that was not a case of second marriage, but essentially two persons living together, and the court raised a presumption of marriage under section 114 of the Evidence Act 1872, since they were living together and presumably cohabiting too. First off, a case is an authority for the proposition that it actually lays down in a given fact matrix, and not for all that which would logically follow from what has been so laid down. First off, in the above circumstances, this petition, this appeal being devoid of merits, is liable to be and accordingly rejected.
And in that case also pension has been allowed.
But we take this. Yes.
Item 9.
Yeah. What's that? Means Hindu law. Yeah.
May I please, Your Lordship? My Lord, in this case, there is a
gender, 16, not legitimate. The second way. What sentence you are using? The word wife, the word wife stroke wife has to be construed in the light of personal law applicable to the deceased employee. In as much as ordinarily in the Islamic law, in the Mohammedan law, a Muhammad can contract multiple marriages subject to all just exceptions. Okay. Next.
May I please?
Item 9.
My lord, in this case, there was inadvertent error, my lord, in the prayer portion, the date was wrongly typed. Lordship, I have filed an application for correction.
Date of what?
Date of, my lord, the impugned judgment.
Impugned order is 30/10/24.
No, my lord. Impugned order is the 9/7/2025.
Judgment of the coordinate bench.
No, my lord. That is against the order of the Lord Central Administrative Tribunal.
Correct.
Lordship.
But judgment is by the coordinate bench. Maybe you are also there.
No, it is not against the writ appeal. It is a writ petition, my lord.
Correct. The mistake occurred where?
Occurred, my lord, before this honorable court, my lord. I wrongly mentioned in the prayer portions.
We have made that order. No, other bench.
Other.
What should be rectified?
Page 10, Lordship, kindly have a glance. The prayer portion of my writ petition.
Writ petition?
Writ petition.
Under the circumstances, it prayed therefore that this honorable court may be gracious simply to issue writ in the nature of certiorari, flashing order dated 30/10/2024, passed in OA number so and so.
Well, that will be 9/7/2025.
9/7/25.
My lord, I have filed an IA to that for amendment of the prayer.
That order of the tribunal. But who appears for the OPs?
No, my lord, notice has not been issued in this case because it has come for first time.
No notice is necessary. It is by the record, na?
Certiorari.
But you have not amended your pleadings.
Yes. I have filed an application for amendment that may be allowed. I have filed the consolidated page also, corrected page.
The prayer column in the writ petition reads as an the said column quotes 30/10/2024 as the date on which OA number 260/0076/2023 came to be disposed of by the Central Administrative Tribunal Cuttack Bench, Cuttack, wide annexure 3, whereas the correct date of the order is 9/7/2025. First off. Therefore, this amendment is sought for in the application in IA number?
IA number, my lord, 57 of 2026.
57 of 2026, accompanied by affidavit. First off. Next paragraph. Notice to other side is dispensed with on the application. Since 9/7/2025 becomes apparent from the very record of the proceedings of the tribe. First off. Therefore, wherever go to prayer.
Page 10.
30/10/2024 is mentioned in the order of the coordinate bench, comma. The same should be construed as 9/7/2025. First off, the registry shall accordingly effect changes in the order in the coordinate bench order and issue a copy, a rectified copy to the parties if applied for. Next.
Item 14.
Petition the loanee. Petition with the loanee avail the loan from the opposite party bank. Accordingly, the bank has fixed for e-auction, but the same has failed. The petitioner made an application before the opposite bank for settlement of the dues. While filing the petition, was directed to constitute the same.
Which is very right under the for OTF.
In fact, there is no right.
You have taken loan, repaid.
Where the home is not mortgage. The home is mortgaged. Now they have a draft outside the.
But home is mortgaged.
Home is
mortgaged.
Home is mortgaged. You with open eyes you did it.
If there is less amount, I am also ready to settle the dues.
You have borrowed, pay that borrowed money before death. It's all public money.
No, I am ready to pay the amount. Directing the opposite bank to settle the. Right, Your Lordship.
Instruction to appear on behalf of concern.
Instruction to agree with the proposal. No.
We don't know.
No, you appear all right, but you have to say something. To say something, you are instructed, or to only say I appear and end of the matter.
What is the matter? We don't know. Let them solve a copy.
Give copy.
Solve the copy.
Give copy. But the question is, where is the cause of action fund, which we can entertain?
In fact, when the e-auction was made by the opposite bank, thereafter the
auction has already taken place.
It is failure. Nobody is participating in the auction process.
Perhaps you are responsible that for the failure. You are ensured that auction does not take place so that you can retain the profit. No case.
I'm ready, ready to clear up the dues.
You pay it right now, entire money. You pay that. I will tell them.
Even if settlement,
settle means what? For lesser amount.
From amount.
You have taken money. You have agreed to the rate of interest. You have given your own house.
This scheme was flouted in the every year, Lordship. If it is coming out of the scheme, it can be settled. Otherwise, I am also ready to.
If you have given
that reason, Lordship, my Lordship direct my friend to take instruction.
No, we are dismissing that. No question of you have to convince us. Then that question arises.
Lordship.
We are not convinced.
Lordship.
We are dismissing the petition. Petition prayer read.
Lordship, one more.
Yes.
In fact, the petition is ready to clear up the due.
Go to the bank immediately, along with the bank, and tell the manager to accept that entire money and relieve your from the coercive proceedings.
In my instruction, the auction process is failed. My friend may take instruction by the.
No question of instruction. If auction fails, the loan liability does not wither away. The liability bulges. It subsists, and because of the passage of time, interest will be added. So liability is enlarged. That you have to satisfy.
I'm ready to already repay the calculation.
The manager to accept the entire money back and relieve you from the coercive proceeding.
My representation is pending before the branch manager. My representation with regard to
where is your right? Where is your right to seek
plus granting liberty to approach the branch manager?
Learned Counsel, having argued the matter at length, now submits that petition be disposed of with liberty to approach the bank manager for amicable settlement in terms of extant RBI guidelines. First up, this prayer is innocuous and therefore rightly it is not objected to by the panel counsel appearing for the bank. Yes. First up, in the above circumstances and with the above observations, petition is disposed of with liberty as sought for. All contentions kept open. Next.
Item 15 also is similar.
15 same.
Similar issue.
And Milord, I may be excused. I mean, VC Milord, item 15 is quite different. Milord, item 15 is quite different.
I am money, borrowing money, not paying it back.
Milord, item 15, Milord, I may.
Item 26.
I am on VC Milord. Item 15 is quite different, Milord.
Item 26. Item 26 is the matter, my lord, lordship may remember. It's a matter relating to recruitment of a driver. 6 posts were advertised.
You were saying that buses are not there. Vehicles are not there.
No, yes, my lord.
But posts are there.
Posts are also not there. But my instruction is there, my lord. Posts are also not there.
With effect from which date they are not there?
Since 1999, they have instructed like this. Since 1999 till date, no appointment to the post of driver under direct recruitment has been made in this collectorate establishment. It is categorically stated that no candidate junior to the petitioner in the merit list.
But the order says, other day you said, any other group D post also.
It is in the contempt probably.
No, there is such an order.
Order. Yes.
It's the last line of the order, I remember. Other day,
yes, my lord. Yes.
Yes. Which is that order? Brother, order that order.
Order dated 9/4. Sir, 3/4/2024.
Read the last portion.
Mr. Additional Standing Counsel is directed to take instruction as to whether the petitioner can be adjusted in any other group D post available with the opposite party's authority or not.
No, not 3424. The order, last line, other day you read that if driver post is not available,
Group D post
we can be accommodated in
Group D
post. This is what you read the other day.
No, man, this is the.
Where is that line? We want to freshen our. My brother was not there. Other brother was there, na?
Sir.
Where is that order?
Sir, this is the order 3/4/2024.
No, it doesn't speak about adjustment and just group D post. Where is that?
Where is that adjustment order?
There is no order about that adjustment of this group D.
There is an order. I have read that. I have read that order. Perhaps you have forgotten.
He was placing on that date.
I have read that order.
Yes.
Go to the order of the tribunal.
Yes, sir.
Go to the order of the tribunal. Where is that order?
Page 15.
Page 15.
Sir. Annexure 5, page 15.
It is expected that it would be
possible to adjust him in
some post
under the collector or under the CDMO within 4 months from the date of receipt of a copy of this order.
No, there is an order. I remember. No, other day you read specifically in this post or in any other post, group D post. Mr. G, you also read that
Yes,
other day.
no, my lord, he was submitting on that.
No, it was shown to us.
Yes, my lord, it was shown. It is, Lordship may kindly have a look to the order dated.
This way is disposed of.
Yes, way is disposed of.
With a direction to the collector.
My lord, the way is disposed of with a direction ascertain from CDMO whether applicant can be appointed in any of the unreserved vacancy at his disposal.
In case he cannot be appointed by the CDMO, then he may be adjusted in some vacancy
at the disposal of the collector,
which is
earmarked for general category
during the economy imposed by the department.
Yes, it is expected that. So possible to adjust him in some post, either by the under the collector, under the CDMO within 4 months from the date of receipt of the order.
Yes. Your contention that there are no posts is not true. Nobody shall be appointed to these posts means there are posts, but recruitment is interdicted. Otherwise, that order would not have been issued at all. Abolition of post is one thing. Interdiction to the recruitment to the post in question is another.
Yes.
Your memo which you have read now, that order, it presupposes existence of the cadre posts. Otherwise, that order would not have been issued at all.
The finance department has issued an instruction not to fill up the posts. Because, my lord, all the posts of maximum drivers posts were abolished. So we are taking,
that?
My lord, that
Before you took time.
It is.
No, this order also reads, but as 2 posts were available in the general category, the case of the applicant was not considered. It is further averred that as against 36 extant posts of driver, 24 drivers are in position. But as no other government vehicle is available, the collector of Hon'Ble is not in a position to issue order of posting. Sanctioned post is there.
Well, but no vehicles are not available because
other posts.
My lord,
leave the vehicles.
My lord, because the driver post is of class 3.
Leave it. There is some order which he is not able to show.
My lord,
which my memory says I have read.
So far as Group D posts are concerned, correct. All Group D posts remaining vacant in any department, head of the department, head of the office would be identified for termination in the changing context of the outsourcing of services, personnel for watch and ward, housekeeping, gardening, security service, etc.
General statement.
My lord, it
affects common sense because many will retire.
It is
many will die.
My lord, it is an office memorandum I am reading dated 31/8/2019 that they have supplied me.
2019.
In
the last 6 years, how many have died? How many have been superannuated? how many have been discharged, how many have been removed. If you get that list, you can be accommodated within 24 hours.
My lord.
Many people have retired.
3 days.
Retirement takes place.
Lordship, call this matter 3 days after.
Call this matter
next week or 3 days after.
On Monday.
Monday, my lord. Monday.
For reporting, hopefully for reporting compliance with the order of the tribunal. In the post of driver or in any
Group D
other Group D post. Where is that order? Nobody is showing that. I remember. I vividly remember.
I also
read that order.
Group D post.
Group D post.
It was probably in the contempt application. It is there.
Next, Tuesday. Correct, on Tuesday. Yes.
Item 27.
No further time will be granted to the learned AGA again. Yes.
Item 27.
I'm for the opposite party.
Where is your friend?
State, my lord. State is
the.
My lord,
generally, we have been taught in administrative law, state is the first enemy of the citizen. Yes, sir.
My lord. My lord. Let's say, give me some time. My lord, always.
Next week.
Next week. Always, my lord, your lordship may kindly vary with the other seat, my lord.
Next week.
It is very. These petitioners are.
Next.
Next week. Suffering a lot, my lord. Even if
let them suffer for 1 week. We'll take it next.
I'll call them all.
Item 28.
Next week. Oh.
Yes.
It will come next week, man.
Next week.
May I please, man?
Yes, sir.
The order dated 21st January 2021, passed in ON number 629 of 2016 by the Honorable CHITTARANJAN Court of Orissa, is impugned before my lord in this litigation manner. Matter relates to grant of temporary status, my lord. My case dismissed by the Law Tribunal only on the ground of limitation. May I pray, my lord, the lordship kindly give a glance, Annexure 6, my lord. Page 31 of the writ petition, my lord.
What is that temporary status? Are there rules?
Yes, on a scheme, my lord.
Scheme. My lord. Are they extra departmental agents?
My lord.
EDS.
EDS. So, my lord, my only submission, right or wrongly, the opposite party no 3 has passed an order, my lord. So, my first priority is to challenge the same by filing an original application, my lord. Accordingly, an original application is filed within 1 year from the date of passing of that impugned order, my lord. But that was dismissed, saying that the matter suffers from delay and laches.
Section 21 is 1 year.
1 year, my lord. 21(1)(a), my lord.
21(1)(a).
21(3) says, tribunal has power, tribunal can condone the delay if satisfied on filing an application for that, my lord. So, my only prayer before, my lord, an order passed in the year 2003 in an original application of 99. That was carried to before, my lord. The writ petition dismissed due to non-removal of defects pointed out of the registry by virtue of parental order, my lord. So the order passed in 19 that was not implemented. So I made a representation. They have not acted upon. So I approached the tribunal. Tribunal say dispose of the representation in compliance to order passed in the earlier original application. They rejected the same, my lord. So I again approached the tribunal and the consequence is Annexure 6, my lord. So that passed on 29/1/2016 and my way was filed within 1 year, my lord. But that was dismissed.
No. In your way,
my lord,
what was the order challenge?
Annexure 7, my lord.
Annexure 7,
my lord. Starts from page 34.
This is order of the tribunal.
Tribunal, my lord.
This order is no. Before the tribunal,
my lord.
What order you had?
Annexure 6, my lord.
Annexure 6. It is dated
29 January 2016, my lord.
29/1/2016.
My lord.
When did you file?
OA, my lord, OA BS number 6/2/9/16.
6/2/9/16. Huh?
629 of 16 is the way number. 629 of 2016.
This was filed on which date? In the month of November 2016.
Month. Date of filing.
Within 1 year, my lord.
It's apparently within 1 year. What was your prayer?
My prayer was to annexure by 8. That was annexed. The present annexure 6 was annexed by 8 before the Lord Tribunal, my lord. And to direct the respondents to implement the order passed in number 34199 in its letter and spirit, and direct the respondents to pay the interest on the entire area of GPA. The rate of interest as if the salary was kept in.
What is the order dated 29/1/2016? What that order said?
They have rejected, said that I am not entitled the benefit of the scheme under Annex 1, my lord.
You are only a temporary employee, part-time employee. You are only a part-time employee. Part-time employees are not entitled to grant of temporary stay.
Yes, my lord.
Then how do you?
I am entitled, my lord. There is a judgment law of this honorable court, my lord.
You that?
Last Roman 3 casual laborer full-time or part-time for the purpose of completion of eligible service, half of the service rendered by the part-time casual laborers should be taken into account. That is, if a part-time casual laborer has served for 480 days in a period of 2 years, he will be treated for the purpose of recruitment to have completed 1 year for as full-time casual laborer.
This is what is the cost title of this case?
Today in Hori Malad, I have only get this much. Because this is
OJC. Can you take out cost title of this OJC?
The OJC number 5246 of 2001.
All this aspect has not been seen by the tribunal at all.
No, my lord.
Tribunal simply said that
Yes.
It is barred by limitation.
My lord.
Who appears for
I am for the madam. I have filed a counter affidavit. Annexure C by 1. So that is not legible. I will file the legible.
No, why tribunal, brother? Why tribunal says it is barred by limitation?
And the petitioner's prayer is not regarding limitation. Kindly have a glance at page 11. Madam. Page 11 of the petition.
Brother,
Madam.
now he is saying, you grant temporary status on us in terms of the CAT judgment, which has been affirmed by the division bench of this court.
Annexure C by 1 said, grant of a temporary status and regulation of casual laborers. In that annexure, that is clarified that the points raised, whether the casual employee who are not initially engaged through employment exchange are entitled to benefit temporary status or not. Clarification is that since it is mandatory to engage casual employees through employment exchange, the appointment of a casual employee without employment exchange is irregular. Hence, such casual employees cannot be vested with the temporary status.
All right. Understood. How the tribunal could dismiss the case on the ground of limitation? The order impugned is 29/1/2016. January 2016.
16 minutes.
The OA is filed in 2016 itself. How the tribunal can say that section 21(1)(a) is attracted? It is within 1 year only. We'll remand the matter. Let the tribunal decide it within 3 months.
The present petition's prayer is separate. He is challenging the under Annexure 7 that is to quash the tribunal's order and directed to grant a temporary status with effect from 29/11.
Anyway, we will see. Tribunal is not justified in treating this case as time barred for 2 reasons. Number 1, it is not time barred, going by arithmetic, simple arithmetic. Order impugned is 29/1/2016. The OA is filed in September 6/29 of 2016. It is filed in September. Where is 1 year? This is number 1. Number 2, even otherwise, whether they have made prayer for extension of the period or not, the tribunal is not a court to expect an application, formal application from the litigants. It is a tribunal. And the constraints of writ proceedings are not applicable to it. Therefore, if it found it is delayed, it should have asked the litigant, hey, Mr. So-and-so, there is delay. What you want to say about that? Tribunal cannot decide that way. The object of having a tribunal is to have no constraints which the writ court suffer from. That is the object. That is which is that the first one is SP Sampath Kumar. And the second one is 97 Supreme Court. L. Chandra Kumar versus Union of India. There it is observed, the object of having a tribunal is to ease out the problems and difficulties of the employees. Therefore, one retired High Court judge, one retired bureaucrat will be sitting as the members of the tribunal. They should give away all these constraints and do substantial justice to the litigant. That standard is lacking in the order now impugned before us. Right now. Petitioner, how many? 1 minute. Petitioner was before the Central Administrative Tribunal Qatar in OA number 629 of 2016, wherein inter alia he had laid a challenge to the order dated 29/1/2016, whereby his request for the conferment of temporary status was negatived on the sole ground that the application was time barred in terms of section 21(1)(a) of the Administrative Tribunals Act 1985. First one. Next paragraph. Learned counsel for the petitioner vehemently argues that the impugned order before the tribunal was dated 29/1/2016 and that OA having been filed in the very same year, the question of delay would remain miles away from the conspectus of section 21 of 1985 Act, and therefore, there being an error apparent on the face of the record, interference of this court is eminently warranted. First off, learned CGC.
So senior panel counsel.
Senior panel counsel representing the union government and its officials vehemently opposed the petition, making a submission in justification of the impugned order and the reasons on which it has been structured. First off, having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence in the matter as under and for the following reasons. 1. Section 21 of the 1985 Act enacts the rule of limitation of 1 year with the power to condone the delay, if any. First off, the reckoning of the period of 1 year has to be from the date of the order that has been put in challenge at the hands of the tribunal. First off, in the instant case at hand, the impugned order was dated 29/1/2016, a copy whereof avails at Annexure 6. The same having been issued by the Superintendent of Post Offices, Mayur Bhanj Division, Baripada. First off, by this order, the prayer of the petitioner for conferment of temporary status has been rejected on the ground that petitioner is in the part-time service and that conferment avails only to full-timers. First off, learned counsel for the petitioner submits that even by simple primary school level arithmetic calculation, the OA 629 of 2016 was filed well within 1 year, which is to be reckoned from 29/1/2016. We agree with this. First off, thus there is an error apparent on the face of the order of the tribunal challenged before us. First off, next paragraph. The vehement submission of learned counsel for the petitioner that a coordinate bench of this court in OJC number 5246 of 2001. Yes. Between so and so disposed of on 29/3/2010 has specifically observed that even a part-timer is also entitled to conferment of temporary status. First off, this order has been made in the light of the decision of the Central Administrative Tribunal in M. John Rose versus HRO, RMS, Trivandrum Division, 1992, 2 SLJ into brackets CAT 243. First off, be that as it may, first off, we do not examine this aspect of the matter since the same fits into pertains to the domain of the tribunal in the light of decision of the apex court in L. Chandrakumar versus Union of India, AR 1997, SC so and so. First off, in the above circumstances, this petition having been allowed, a writ of certiorari issues quashing the impugned order of the tribunal. First off, matter is remitted to the portals of the tribunal for consideration afresh, keeping open all contentions except the issue of limitation which would not arise in the matter. So for a challenge to the order dated 29/1/2016 made by the Superintendent of Posts is concerned. First of all contentions are kept open. Tribunal is requested to hear and dispose of the OA within an outer limit of 6 months. Well, 6 months.
Yeah.
Item 29.
Internet, you'll also kindly take on next week.
Next week? All right. 2 weeks at the request of.
Item 30 has been adjourned. Item 31.
Yes, brother. I am for the respondent.
I'm for the appellant.
Yeah.
Your Lordship, in this matter, Ms. Rath is senior advocate. She's engaged in this matter. She's on her legs. Can I start the matter till she?
She's on her feet.
She's on her feet. Yes, she is arguing in another court.
Okay.
May I please the matter till she comes because I don't want.
Whether that arguing counsel is from.
I have engaged.
Counsel on record you are.
Yes.
She's arguing counsel.
Yes.
He's from Katakundi.
Miss Pami Rath, she's engaged in this matter.
Next week we'll have this matter.
Next week.
Well,
not on 21st, my lord. Not on 21st. Any other? Next week.
21st?
Not on 21st.
No. Yes, 22nd all right. My lord, no problem. 27. Yes.
Item 32.
Your Lordship, I'm really sorry. 22nd, I'm not available. 28th.
Have we called 28th then?
28. 28. Yes.
28. Yes.
Item 32.
32, 33 and 34. All the three matters, my lord, 1 week after or 2 weeks after, because there are some latches.
32, 33, 34.
Item 32, I'm for the respondent, your lordship. She was the
you finally.
Yes. As a lordship pleases.
2 weeks. Finally. At the request of Mr. G. Yeah.
My lord, in 33, there is some complaint that state, my lord, had directed.
Meanwhile, complaints, office objection.
I'll do that.
With. Yes.
Must get proven.
Item 35.
35 also what I prayed for ballot 1.
2 weeks as the request of the constituency. Next.
Only one small request, your lordship. A date may be fixed, your lordship. 32 item.
All these matters, my lord, lordship may call this matter in 1 day. We shall finish all this case.
On 4th of February.
Yes.
As the lordship pleases. I'm grateful.
Yes.
Item 36.
May I please, your Lordship?
Yes.
In item 36. Since your Lordship, we are the directed, they should file counter, your Lordship. Last occasion, your Lordship directed to file requisite for issuance of notice and they have received the notice. Till that, they have not filed counter, your Lordship.
You have not paid counter. You can take advantage of that.
Yes,
Mr. G.
36 is for Union of India.
Union of India. Who appears for Union?
No, but the state is the contesting party.
State is the contesting party. You have nothing to say.
No, we'll file out.
Let's say whether you're ready, not ready. Something has to happen now in the court hall.
But I will take
online court it is.
I will take instruction.
Let us.
I will take instruction.
Call up to 3 weeks at the request of the CGC or CGC.
No, senior pen.
Yes, senior panel. Yes.
Item 37.
Yes, 37.
This even melody challenge to the Honorable Single is order dated 20th September 2025.
726 order.
Yes, ma'am.
What it says?
Before I go to the impugned order, may I just not still the backdrop for fact.
No.
But an award was passed by the micro small medium facilitation council on 10th of July 2023. It's my date chart, your lordship can have it.
You have date chart?
Yes, I have date chart. I'm referring to
who is your opponent?
My
yes, ma'am.
Yeah, that is there.
Now, serial number 5, I have stated that on 10th July 2023, the award is passed.
Then 7.
Yes, ma'am, 10th July.
23 is the award.
Award. No, my lord, it's under 18.3 is the arbitration award. So it was challenged on 28 or an application for setting aside was filed on 28th March 2024.
No, 8/7/23 is the award.
10th July.
10/7/23 is the award.
Yes, madam.
That was put in challenge under section 34.
34.
Section 34 is invoked on which date? That was, challenge was filed under
28 March 2024. About 174 days delay.
1274
days delay.
How?
174.
174 it must be.
174 days.
Yes, ma'am.
No, sir. 170.
I have written 174 days delay. I have stated it. Now, be that as it may, it was never admitted. Then an application for withdrawal of the said action was filed.
Withdrawal of 34 proceedings.
34, and that's
withdrawal was filed on
21st October. It was filed on 24th September 2024.
24/9/2024.
Yes, my lord. 24th September 2024.
Yes.
And it was allowed on 21st October 2024.
Yes.
After that, a writ application has been filed. The present writ application was filed.
After withdrawal.
After withdrawal. And
who filed it?
The respondent, sole respondent. Yes, ma'am. So the withdrawal, it is categorically the order was unconditional withdrawal without any further.
Like 23-3.
23-1.
23-1.
23-1-3 will come. It was unconditionally withdrawn. Then this writ application was filed. So in the writ application, there are two grounds has been.
No, what is challenged?
Yes, the challenge is to the award.
Challenge is to the award.
Award dated 10th.
Is being withdrawn.
Yes.
Award is put in challenge. Award is dated
10/7/20. But here the two grounds they have exposed for challenge. A, that my registration as an MSME is after the contract date.
That dispute relating to contract.
No.
The contract having been entered into much before the registration of the MSME.
Yes, before filing of the memorandum under Section 8 of the MSME Act. That's number one. And number two is, this agreement is a worse contract. Therefore,
what contracts are not covered?
No, that is right. Therefore, even though the arbitration clause is there,
it is worse contract.
It cannot be arbitrable by the MSME. Am I clear, my lord? Yes, ma'am. Now, the Honorable Single Judge has framed three issues. And that's directly in the our order, impugned order. I can take your lordship's attention.
Two issues they raised. One is, if the contract from which the dispute arises is anterior to registration of the MSME under the Act.
Yes, madam.
The Act is not applicable.
That's number one.
Number two is,
it's a worse contract.
If it is a worse contract, then it is not within the domain of MSME tribunal.
That's so.
If I may, Your Lords, my essential premise was, when I approached the court under 227, was that I raised a plea of inherent lack of jurisdiction. This is very key to my case.
Yes, madam.
I'll just take 30 seconds because you've articulated. I want to see what specified.
Therefore, award is nullity.
Is a nullity. That's my case.
Therefore, it can be put in challenge wherever it is sought to be.
At any time, even in writ or collateral proceeding, I'll show those line of judgment.
54 Supreme Court.
Absolutely. From there onwards.
Charan Singh versus Chaman Paswan. Kiran Singh Chaman Paswan.
My lords, right from 54 to 2025. We'll show that line of judgment.
So, my lords, inherent lack of jurisdiction premised on registration well after the contract, number one. Two, works contract. So, in any event, the MSME Council could not have touched this matter, which is why my premise of inherent lack of jurisdiction. That's all. I won't interfere right now. I'll show my lords a line of them.
So, what the inherent lack
But Kiran Singh is three judgment.
It's a three judgments.
Yes.
So, my lord, this was my friend said, they now branded that these two defects as the inherent lack of jurisdiction, and that has been raised before the Honorable Single Judge. Honorable Single Judge framed three issues. One is that whether the present opposite party registration date MSME being after the date of the contract would have any bearing on the matter. That's issue number one.
Did you dispute that proposition? That the contract was entered into anterior to registration? No.
No, I am not disputing that. Actually, I am not disputing anything.
Facts are, you admit the facts.
Facts except that was contract. This I am not disputing.
What's contract you
disputing?
But assuming that was contract.
Even assuming I have a case. Even assuming it's was contract, then also have a case.
Because there is an award.
I'll go to those. So, insofar as the first issue is concerned, that is answered in my favor. Holding that I can raise, and that's also the Honorable Apex Court's decision. So, holding it is that even anterior,
even they can be matter of subject matter of adjudication at the end of in the arbitration proceedings of the tribunal.
In the MSFC, by the MSFC. So, because your beneficial list, all these have been taken care of by the Honorable Apex Court. So that issue has now resolved in my favor. That's not an issue. The second one is works contract. Now here, my lord, before I go there, I have three submissions. A contract interpretation is required to say whether it is works contract or not.
It's a mixed question of
It's a pure question of fact.
Pure question of
it's
fact.
a pure question of fact. Because interpretation of contract must be done upon a laying of evidence and appreciation of evidence.
Salmond, in his jurisprudence, 12th edition by Fitzgerald, treats question of law, question of fact. What Salmond says is, all questions that arise before the court or tribunal are of four categories and no other category. One is question of law. He says a question answer to which has to be found by turning the pages of the statute book is a question of law. Suppose if A causes death by stabbing B, whether that amounts to murder or not, culpable homicide amounting to murder or not, the answer has to be found in section 299 and 300 of IPC. Therefore, it's a question of law. Question of fact.
Whether the person has
any fact which is to be established by leading evidence. Their English jury system. Any fact, any question that is addressed by the jury is a question of fact. Whether A stabbed B to death is a question of fact. Whether Alexander had come to India in BC 323 is a question of fact.
Yes, ma'am.
Question of law, question of fact. The third one is question of opinion. Whether person like Alexander will come in AD 2029 is a question of opinion. Inform opinion depending upon certain factors. Someone gives a company, whether the company earned profit in the preceding financial year is a question of fact because evidence will be there. Whether company will earn profits in the next year is a question of opinion because we do not know. Then the last one is question of discretion. Whether 3-year imprisonment should be given or 7 years imprisonment should be given. Whether life imprisonment should be given or death penalty should be awarded. These are questions of discretion. So your point, whether a particular arrangement amounts to works contract or not is a question of fact, because evidence has to be looked in.
Yes.
Whether a works contract is defined under the Act?
No.
It is not defined.
Not defined. It is defined in GST Act.
GST Act that is generally
Now also that is settled at rest. Now works contract is defined under the GST Act, and
it can be traveled to GST Act.
No, my lord, if your lordship for an aid to interpret it, and it is put in the category of service. Under the GST Act in 2017, not
a service.
It is a service.
Service component is taxable.
No, my lord, that's taxable as a service component in GST. It is stated. So I can go to that. I'll go. Okay. So now, my first point is that this appreciation of contract
needs evidence.
Needs evidence. That's number one. Number two, at the behest of a party who has already suffered, has not raised this question ever in the totality of the proceeding. Never draw the attention of the tribunal to these questions that whether this is an can he raise it for the first time by invoking 226. That's number two. Well, staying on that and the subject, can he do it after withdrawal, after abandonment, and
unconditionally?
Yes.
Did he say the reason in the application for withdrawal?
No.
No reason is
no. I've annexed it. So that's the third. It's in fact disturbing the public policy of finality. And that's how it has been interpreted by the Honorable Apex Court. And that it has gone to the extent of saying that once you withdraw the suit unconditionally, the writ remedy is also illusory on that premises. And the Honorable Court has used this phrase like constructive res judicata. So this is the second. Now,
res judicata. Where is adjudication?
Constructive res judicata. They have put it. It cannot.
No adjudication at all.
It can.
To say res judicata.
But I am not saying, my lord. I'm just saying the Honorable Apex Court has said. I am not saying.
Almost to res judicata.
That's what the Honorable Apex Court. And section 2. I forget, but I just.
I doubt that.
I doubt.
Yes.
So this is. Now, my lord, already this matter argued before the Honorable Division Bench, First Division Bench, led by Honorable Chief Justice. Now, your lordship can have that order dated 7th January 2026. There also the Honorable Court has framed questions. May I just place it?
Yes.
Two seminal points appears to have been arising in the instant appeal.
No, you have argued now. They have to argue.
I have not finished.
What is that finished? That's you are in 227.
226, this is decided.
It cannot be. It is 227 because the award of the tribunal is put in challenge. 65, one Supreme Court.
My lord, the Honorable
that they've been used by all lawyers. All kinds
no, honorable single judge in the order say it is exercising jurisdiction under paragraph 35. It's finding it's not contention. Your lordship can have. The court has already held time and again that access of High Court by way of writ petition 226 of India is not. And he is actually the Honorable Court has actually exercised his jurisdiction.
It is because
it is
5-judge bench of the Supreme Court in 65 Miraskal. Take out that judgment.
And Miraskal is 1960, AIR 1960, page 1. Naresh Mirzakar, that's the 9-judge bench.
Correct. There they say where
that is how it is followed.
Order is put in challenge. Then it is 227.
That is how it is followed in that the only aberration is that when we take this civil court's order, whether it is amenable to 226 or not, that's how it is settled that it is only 227. That's that's the ratio. So here the Honorable single judge has said, I am not saying that's I'm just clarifying it. In the issue itself, your lordship can see at page 37.
AR 67 AC.
16, page 1.
67.
67, page 1.
Yes.
Now, Lordship, can you see can you have at page 37, the issues?
We have understood your case. First one is, you say it is an award by a statutory authority, number one, and award was challenged under 34. That came to be withdrawn unconditionally.
Yes.
Therefore, challenge to the award in dead jurisdiction is barred. That is one contention. Number two, whether there was a works contract to exclude it from the purview of the council is a question of fact on which evidence needs to be laid. Therefore, once there is an award, to set aside on question of fact, the only remedy is 34, which they have exhausted in a way, and therefore dead jurisdiction could not have.
Staying on the same point, this point, though they have participated before the tribunal, have never raised neither before the tribunal nor in the 34. For the first time, can they take it?
Yes.
And post passing of the limitation period, whether they can avail the writ remedy or not, that also.
Once, again, it is mixed because once they say it is no award at all, the question of limitation would not arise.
No, I will still say.
There was. There was. Yeah, anyway, I understood. I listen. Yes, sir. Yes, sir. What is?
So as I had submitted earlier, my challenge was inherent lack of jurisdiction premised on 2 grounds.
On what ground you had challenged before the tribe, the 34?
On what grounds?
What are the grounds?
My learned friend, because he was in the 34.
Yeah. What were the grounds? Where is your
the 34 application is not
annexed.
It's annexed.
I have annexed.
You annexed?
I have annexed.
34. What are the grounds you have
Page 71.
The grounds which have been set out before the writ court, Hon'Ble writ court, were not taken in 34. Lord, the premise of my challenge was that, as my lord said, if an award is a nullity because of lack of inherent jurisdiction, then, my lord, I will present before your lordships the views taken by different courts, then 34 would not lie. Because if the law considers that there is no award in existence.
That's your assumption.
Yes, ma'am. I'm coming.
It is no award.
Yes, ma'am. Yes, ma'am. So, what the award in the analysis says, it's a supply and service work contract.
What was your contention before the council?
Lord, this contention was not raised before the.
You had not taken up.
Not taken. Lord, I will make that.
Participated in the proceedings.
We did, ma'am.
That contention you did not take up.
Not take.
Award came to be passed.
Yes, ma'am.
And you challenged it under 34.
Yes, ma'am.
You withdraw it unconditionally. And all of a sudden you say before the writ court that it is without jurisdiction.
Lord, I'll just make 4 points, ma'am. Just 4 points. This is precisely the fact, ma'am. Lord, the fact that it's a work contract, it is written in the agreement which was presented before the court. That's a work contract. And then it has certain attributes to it, as in, if it is a work contract, some relaxation or concessions will not be available to the bidders and all that. Be that as it may, my lord. Its contention was not raised by either of the parties, but it is clearly recorded. Your lordship may have this compilation. I'll just draw your lordship's attention to that one line where the tribunal categorically records that it is a work contract. Now, that finding is not challenged by them also. That observation is not challenged by them. So therefore, insofar as facts are concerned, there is no challenge.
How a finding can be challenged by them? No, award can be challenged.
Award.
How finding a wrong finding is to be challenged by them?
Lord, be that as it may, Lord,
I'm
follow.
asking you.
I follow.
We want to know from you.
Lord, they are the beneficiary in the award, so they may not.
We are asking you.
My lord.
What is challenged in a civil proceeding is decree.
Yes.
Not finding adverse to the decree holder.
Yes.
In your challenge, because of Order 43, Rule 25 or 23 or 26, kindly look into, of amended CPC.
That's true.
An adverse finding can be challenged by the decree holder when the decree is put in challenge by the judgment debtor.
That's the law, perhaps.
Yes.
96 Supreme Court.
I bow into that. Yes, madam.
If that is so, how can he challenge an adverse findings?
No,
the
I-
award which has gone in his favor.
No, I leave it there. My lord. I agree with what bench says, my lord. Not the tribunal notes that in paragraph 19 of this compilation, Lordship may have it, says the respondent IOCL had awarded a supply and services work contract, which is not which was never in dispute. So what was given to them was a work order for construction of tanks. It is that they will procure everything required in the lump sum contract and execute the work.
So
it is indivisible.
There is a finding. There is a finding.
Supply and services work contract. The award says
there is a finding in the award to the effect that it was a works contract.
It was a works contract. Now, my lord.
And therefore, in the absence of challenge thereto, the finding binds both the sides. Which aspect has been pressed into before the High Court?
Well, now, my lord.
In view of that, a nullity is a nullity is a nullity.
Is a nullity.
That's your
nullity is a nullity. Now, my lord. Now, essentially, my lord, what I did, my lord, under section 34, I withdrew it unconditionally because in the meantime, there was an execution pending and a section 47 application filed in the execution court saying, please declare it to be a nullity. Parallelly, my lord, I moved under 227 saying it's a nullity, kindly declare it to be a nullity. Now, my lord, the Honorable Writ Court. Now, my lord, there are two propositions raised by them. Whether a writ petition is maintainable directly against an order of the tribunal is the first question framed by Honorable Chief Justice, my lord, in the last date of hearing. And the second is whether 23 Rule 1(4) is a bar to me. Whether I have abandoned a right. My lord, it is something which can't be waived. The law is well settled. If it is a nullity, and I am not very conscious when I make the statement, but here we are not dealing with a jurisdictional issue, a plain jurisdictional issue, or an issue of limitation. No, I am dealing with a jurisdiction which is inherently lacked. So, not clear distinction. There is no difficulty. Now, I'm not learned single judge exercises his discretion under 227. That is also a settled law that it is discretionarily. I may have an alternate remedy, but my submission is twofold. Number one, if it is nullity, 34 is not applicable, I will place the law on record. Two, even if a alternate remedy is available, my lord, this court has power to exercise discretion, which discretion has been exercised in my favor, and it has been held that it is a work contract and fall outside the purview of, my lord, why? There's another thing, my lord. What he was, my lord, what MSME Act says is, if I may just sum up in two sentences, my lord, it says a summary trial where a party who has either supplied or has provided services, not indivisible contract. If it is both, then it is no evidence is required. If a contract is for supply and service, it's over. Yeah. Now, my lord, it is not their case. It has never been their case that no, it was only for supply or for work or as in the service. No, it has never been their case. Even today, it is not their case. And my lord, now what happens is, the court still gets into that question and says, let us see, let us examine. Then all the Supreme Court judgment, recent judgment, because the jurisprudence is evolving a lot, Gujarat High Court gave a view and then Supreme Court and Shilpi says that yes, perhaps a work contract you will not touch and all that. So the learned single judge gets into that question and decides that yes, since it is a work contract, I exercise my jurisdiction into 227. Now, my lord, the new point which has been raised here, which has been crystallized by Honorable Chief Justices, is 2314. Lord, may I just place 3 illustrations before your lordship, and I will give side judgment for one judgment for each of those illustrations. There could be 3 possibilities.
What you will say is, regardless of illustration, 23(1) is, it does not come in the way of your challenging the award in writ petition.
Yes, madam.
That's your condition.
Yes, madam. And I will, my lord, there are 2 propositions. I'm dealing with the first. I will just give 3 illustrations. The lordship may consider there could be 3 possibilities. An award is not challenged at all under 34. The question is whether my right to challenge on the ground of nullity before anywhere or everywhere can be compromised. First. Second.
That for that 54 Supreme Court.
Yes, ma'am. 2. Section 34 is filed, but this ground is not taken. The nullity ground is not taken. Can it be raised subsequently or anywhere or everywhere? That is 37 or maybe in Supreme Court in SLP or anywhere else, writ or collateral proceedings. 3 million. Then I file a 34. I don't raise this ground and withdraw it unconditionally. have I abandoned a right? The question is whether a party can actually abandon or even by consent can we waive that right. No, my lord. It is a fundamental policy of Indian law that a nullity is a nullity. And for the first time, and my lord, all these three instances have happened. And second proposition is, my lord.
No, not like that. Your proposition appears to be too wide, which Wade and Forsyth on administrative law do not agree, and Apex Court did not agree. Take out 92 Supreme Court. Take out 1992 Supreme Court. Take out your judgment from there. This is treated by the three-judge bench of the Apex Court in which single case? 92, page 111. Take out that judgment. This proposition is castigated by the Apex Court. Apex Court referred to Wade and Forsyth on administrative law and said that even if it is a nullity, a proper proceeding has to be taken up for establishing the nullity. Otherwise, for all practical purposes, it would remain as an impeccable order.
No.
Hey, do you have your...
my colleague is finding out the judgment.
Gurudev Singh versus State of Punjab. Take out that judgment.
Lord, I'll examine that judgment, Lord. May I just cite three judgments, the recent judgments, Lord?
Your propositions appear to be
Lord,
little transcending the contemporary ideas of administrative law, which Apex Court has said. Just for a moment, I'll read one paragraph to reject your contention. Take out here. Go to this one. They quoted a decision of English judge, judge of very great eminence. Go to paragraph 5. Gurudev Singh, yes, 1992 SC, page 111. 111 you are taking. AR 1992 SC, 111. Your argument is rejected by the Apex Court. My lord, kindly read para 5 and 6. They quoted Wade and Forsyth, administrative law. You take out that paragraph. Not coming out. Can anybody pull out that judgment?
Lord, it's there.
Yes, read that judgment.
No, may I? Para 5 says,
yes.
In the instant case, the respondents were dismissed from service.
Yes.
Maybe illegally. The order of dismissal has clearly infringed their right to continue in the service, and indeed, they were precluded from attending the office from the date of their dismissal. They have not been paid their salary from that date. They came forward to the court with a grievance that their dismissal from service was no dismissal in law. Nullity. According to them, the order of dismissal was illegal, inoperative, and not binding on them. They wanted the court to declare that their dismissal was void and inoperative and not binding on them, and they continue to be in service. For the purpose of these cases, we may assume that the order of dismissal was void, inoperative, and ultra vires, and not voidable. If an act is void or ultra vires, it is enough for the court to declare it so, and it collapses automatically. It need not be set aside. The aggrieved party can simply seek a declaration that it is void and not binding upon them. A declaration merely declares the existing state of affairs and does not quash so as to produce a new state of affairs. But nonetheless, the impugned dismissal order...
this is important.
But nonetheless, the impugned dismissal order has at least a de facto operation unless and until it is declared to be void or nullity by a competent body or court. My lord, I vote on that.
Competent body. Next, read.
Yes,
it's not over.
My lord. In Smith versus East Alloy Rural District Council, Lord Redcliffe observed. Yes. An order, even if not made in good faith.
In English law, good faith goes to the root of the matter.
Yes,
unlike in our law.
Is still an act capable of legal consequences. It bears no brand of
invalidity on its forehead.
Yes, Lord. Upon its forehead. Lordship.
Yes, read further.
But I'm out on that. Unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset, it will remain as
impeccable
for its ostensible purpose as the most impeccable
of the orders. Go further.
Propose to this principle, Professor Wade states,
yes,
the principle must be equally true, even where the brand of
invalidity is plainly visible on the forehead.
For there also the order can effectively be resisted in law only by obtaining the decision of a court. He further sums up the principles.
Yes.
The truth of the matter is that the court will invalidate an order only if the right remedy is sought by the right person in the right proceedings and circumstances.
Right remedy is sought in the right proceeding.
Yes, ma'am. And circumstances.
And within the time limit.
Yes, ma'am.
Yes.
The order may be hypothetically nullity, but the court may refuse to quash it because of the plaintiff's lack of standing.
Correct.
Because he does not deserve a discretionary remedy. Because he has waived his rights.
Yes.
Or for some other legal reason.
Some other legal reason.
In any such case, the void
order remains to be valid
and is in reality valid. It follows that an order may be void for one purpose and valid for another, and that it may be void against one person but valid against another.
Correct.
It will be clear from these principles that the party aggrieved by the invalidity of the order has to approach the court for relief of declaration that the order against him is inoperative and not binding upon him. He must approach the court within the prescribed limit of limitation.
Yes.
If the statutory limit time limit expires, the court cannot give the declaration sought. Now, Lord, I appreciate this. Now, may I just make good my proposition? Lord, I understand the extreme argument that I have taken that perhaps 34 is not a remedy at all, my lord, that the Jharkhand High Court says, but Supreme Court has upheld it. Be that as it may, my lord, my proposition otherwise is very simple. That there could be two jurisdictional errors. One which can be waived. Like, I say the appointment of the arbitrator is not correct. I raise an objection under 16, which comes to be dismissed. And then I don't challenge it or don't take that ground in 34. Section 4 of the Arbitration Act would come on my face and bar me. Or if I don't take that plea before 16.
All accepted.
Yes, ma'am.
What is your conduct?
Lord.
You challenge it before 34?
Yes, my lord.
You withdraw it unconditionally?
Yes, my lord.
In the challenge, you did not take up the contention that it is a nullity?
My lord.
Nor you took up any other ground as are available within the conspectus of 34?
My lord.
Unconditionally having withdrawn, all of a sudden you present a writ petition for challenging.
No, it's not that. Lord, I mean,
that is a factor.
Lord, I understand. Yes, that faith is a factor, my lord. I understand. My lord, allow me to make it good, my lord. What actually transpired in this case is that when the 34 was pending, an execution came to be filed. And in that execution petition, we filed an objection under section 47. Now, my lord, the irony is this Honorable High Court in Barachan has taken a view, a single judge has taken a view that section 47 will not lie in execution petition because award is not a decree. That is the ratio.
No, principle will be applicable.
Lord, that's correct.
Assuming that 47 in terms may not be applicable.
Yes, my lord.
There are judgment. Mullah says that 47 it enacts the general principle.
Lord, Anusuya Devi says that
judgment.
For suppose stamping.
Correct.
Non-stamping. 47. You take that objection. Rather, that is the first time you can raise. But, my lord, unfortunately, the execution court dismisses that 47 on the ground that in view of Barachan, I can't do anything. So, my lord, a second petition came and there is a second order operating against them which is not in the challenge, which also says it is a work contract. I had taken the remedy before execution court under 47. It came to be challenged on the ground that 47 is not.
Which is that order?
Yes, my lord. That order is. That second order is not dated.
Second order, what it said?
I'm just correcting my friend on facts. That is already challenged.
Not we have not,
appeal is pending.
Not we have not.
Its appeal is pending.
Yes, ma'am. Appeal is pending. So I was just correcting him fact or nothing. And this and the second order, the honorable single judge.
Writ appeal comes before whom? It comes before me. We first only.
It will come before you.
We'll call that matter also.
My lord, then your lordship may have it someday, my lord. Also.
Both matters.
Because we need to file, my lord.
That's
that matter was heard at length. Several contentions have been canvassed by the sides. Subject appearing for the respondent submits, and the counsel appearing for the petitioner does not dispute that writ appeal number so and so is pending, which arose from an order of the learned single judge in the writ petition filed by the respondent, laying a challenge to the rejection of the resistance under section 47, order 47, rules 1 and 2 of CPC in the execution proceedings. First of all, therefore, it is submitted at the bar rightly that both the matters should be taken up together. First of all,
I will give them a copy.
Counsel are put to knowledge that they shall not repeat any ground which they have already urged today when other matters are taken up. You are not supposed to repeat anything because we remember everything. Yes. And tomorrow. Tomorrow, because you are already, we have heard the matter. Before our memory fades. Tomorrow we have to do before the memory fades.
Holiday. Tomorrow.
Day after.
Yes, 15.
Day after.
So sorry, Lord, I have a full day argument in Delhi. Lord, I have traveled from there. If Lordship can bear with me.
You can argue online also. No problem.
Can it be next week, Manoj?
Before our memory fades.
My lords, when you can refer to a 54 judgment, House of Lords, my lords, your memory will fade.
One more small thing, Lord. I need to take instructions. Perhaps Indian Oil will also be challenging a part of that rate where the first court also says that 47 is not maintainable, because now Supreme Court is very clear, my lord, in the recent judgment that 47 indeed is the remedy. So your lordship may give us some.
54 Supreme Court, Kiran Singh said.
I appreciate, but
when the order, it uses the word decree or order, those not award.
That's right,
This one, but on conduct you have to submit to us.
I will
make court.
I will make submission.
Therefore, it should be on conduct. There is another aspect. If it is 227, whether intra-court appeal is maintainable, that you have to answer.
Fortunately for me, the Hon'Ble single judge has held.
No, the single judge may say so many things.
No, 226.
Let us see. Single judge saying that it is under 226 does not make it under 227 for the diligent bench.
That's correct. That's correct, my lord. My lords, as far as the big state is concerned, because both of us are doing this matter together now. I am based here, so I don't have that.
Not 30th of January, if you lordship. But
no,
they will certainly be here. Certainly, yes.
Well, then you are 19th week, your lordship.
He has to travel from Delhi.
I'm sorry.
You should allow people to come to this place so that you will be benefited, they will be benefited, mutual benefit will happen. Perhaps we also. Yes.
I take that excuse that I'm from Delhi, but then when my learned friend found out I stay in Bhubaneswar,
no problem. Which date you want?
31st, whatever your lordships.
Would 31st be?
31st is Saturday. 31st is Saturday.
30th, you know, sitting. 30th week.
30th.
I just.
No.
Can we have it on 29? Whether your diary is free?
My lords, I'm in some difficulty.
28. We'll go in the reverse gear now.
I'm so sorry. I'm so sorry. I am attending my brother's marriage, my lord. I should not lie before you.
30th.
I'm so
I have a small prayer here.
Yes.
I have filed a miscase. Actually, they are going for recovery on the basis of this. So let the lordship have that last order. There is an undertaking by my friend.
My lord, that undertaking.
We will not know that.
We will not.
So that can be stayed. I have.
No, it is already
undertaking given
on 7th.
We will not precipitate the matter
respondents. In the which is recorded in the
last order
dated
7th January
2026 before the learned single judge.
No.
Before the coordinated bench. He is renewed here. Okay. Next.
Item 38.
In fact, I am for the opposite parties.
Where is your friend? Any entry order is there?
No entry order is there.
All right. 2 weeks to enable counsel for the petitioner to come and argue. Appellant to come and argue. Appellant or petitioner? Petitioner to come and argue. Yes.
Item 39.
My lord, item 39, I am appearing on behalf of the opponent party. I will be permitted 2 weeks time to file the counter.
3 weeks for filing the counter, if any, within any, failing which right to file one stands forfeited. And petition amendments will be taken with face value. Yes.
Item 40.
40.
My lord, I am appearing for the opposite party, my lord. I have already took time for the counter. Counter is ready for meeting. I will file it on 19th. I am ready. I was that successful proceeding.
If Rani of Jhansi agrees, then we'll give him.
Because I have sent the counter for betting. On 19th.
You file after giving copy to madam.
Yes, on 19th I will file and solve the copy.
Call speak. To enable the OPs, the respondents to file, OPs to file their counter. Yes.
Item 41.
Yes. Yes. Next.
Item 41.
Yes, Mr. Sarangi.
My lord, they have given an electric power connection, your lordship, 3-phase connection without my consent to my tenant. The GRF has allowed it. I went to the ombudsman. Ombudsman said that it is not maintainable. I had approached in between your lordship in a single bench.
Whether consent of the power is given to the tenant?
Tenant. Power was there. 3-phase connection is now given without. 3-phase connection is given now without my consent, though the statute.
Whether consent of the landlord is a must under your rules.
Sir, there is a small correction factor. We never intended to give
My lords asked you a straight question.
Consent. There is a provision that consent is required. There is a state regulation, but the factual correction is we never intended to give power supply to the tenant. The tenant went to GRF without impleading the landlord as a party
and got the order.
GRF asked us to give him supply. We give them supply. Then instead of challenging that order, the petitioner went to higher forum, that is the ombudsman, without challenging the order and without impleading him as a party. So he never impledes him as a party,
and he never impledes
him as a party. And nobody challenges the GRF order by virtue of which we are directed to give the supply.
Yes, Mr. Sarangi.
Yes, my lord.
You have no case. You challenge that order. We'll permit you to challenge that order.
Now that's the order I had challenged here. Your lordship said it is not.
No, that order has to be challenged before the appropriate authority.
Ombudsman.
What I'm submitting, my lord, I will go back to the GRF. Let the GRF give opportunity to all parties concerned and let it be disposed of. That will be the easiest way out, I guess.
Yes. Both the sides. We will say that we suggested to you instead of you suggesting that to us. Otherwise, the ombudsman or the tribunal will have both the sides having argued the matter for some time very fairly agree with the suggestion of this court that the petitioner should approach the GRF afresh with all contentions as are taken in this petition, and also more. And that the GRF should decide the matter after hearing all the stakeholders, including the tenant of petitioner.
Present OP4.
OP number 4. OP number 4. On merits. And matter to be disposed of within an outer limit of 6 months.
6 months is a very...
2 months, 4 months. First, ordered accordingly and writ petition is disposed of. Okay.
Item 42.
42.
May it please your lordship.
Yes.
42, my lords. I have to have back up all the appearing matter. 2 weeks time when the counter, because in the
why you are not giving the sale certificate?
Sale certificate and possession also they have asked for.
Possession also.
Yes, ma'am.
Why are you not giving? 2016 matter.
Yes, Lordship.
2016 matter. Other day.
Paid the entire amount in 2016 itself.
We will impose 5 lakh rupees cost.
But I will verify my lord because in the
Verify, you tell your clients that the court is going to impose 5 lakh rupees cost. Having taken money from the successful bidder, retaining that money, retaining the property. Bank doing this. Is it a private bank?
No,
No, public sector.
Bank of Baroda.
Yes.
But as per my oral instruction, various cases have been filed in different forums. ma'am.
Let them file. Why you should not give the certificate?
So if some interim order is there or something.
You say that.
I will verify.
For that purpose, we have notice.
Huh?
For that purpose, we have no notice and we have filed an affidavit also.
I will verify my lords, and for the first time after 9 years they have come before your lordship. No,
Well, they waited because they wanted you to wake up and you did not wake up.
We filed
Necessary.
a representation.
You call this matter on Wednesday. Finally, at the request of Learned Counsel appearing.
We are serving the copy of our
for
affidavit.
the bank.
We are serving the copy of our affidavit that we have filed. Yes.
You give copy. Yes. We will impose very heavy cost because in Karnataka that court has imposed 10 lakhs. It will impose at least 5 lakhs. Yes.
But in the meantime, as per the noting, my lord,
In the meanwhile, if you bring the sale certificate, perhaps we may not impose the cost at all. Otherwise, cost. That will retain that money. No other person will come forward for auctioning. Yes.
Obliged.
Item 43.
This lady also argues very.
43, you already decided one matter yesterday, item number 7.
Yesterday, item number 7.
Yesterday, item number 7, that railway matter, that's order has been confirmed by the Supreme Court. Basing upon that, so many cases were filed. And your lordship, MICP matter, your lordship disposed of WPC number.
Covered by judgment.
Yes. My
lord, on last occasion, my learned senior is also intimating me, and I came to know that yesterday matter was disposed of.
395.
One thing, my lord, on the last occasion, this what I want to bring, my lord. On the last occasion, I want for the time to got certain instruction with regard to that which they have supplied me. In the instant case, what happened, my lord? There is my learned friend which is saying that is the principal bench of CAT that was challenged before the Hon'Ble High Court and thereafter Supreme Court. Supreme Court in peculiar servant that has been done, that is according to his, and I came to know what, my lord, in this case, my lord, the same issue that has been decided by the learned CAT of the Calcutta High Court, where the Calcutta bench, my lord, Calcutta bench, where, my lord, it has been observed that similarly when this has been allowed, but they have not allowed. In view of the above, we fail to concur with the view that the placement of the Mistris in GP 208 to that supervisor IOW in grade 402 under a modified selection procedure on the basis of the ACR. Following the reservation policies, we change in nomenclature due to cadre of restructuring and pay fixation in terms of the FR. So and so, bid was not a promotion. So that
but Apex Court, you have already lost the case at the Apex Court level.
My lord, what I want to submit, my lord, my humble submission that suppose why I am taking time for that extent. If that is that is settled, my lord, if that order has been challenged, then what is the consequence of if it is
we have already taken the view.
Yes.
You challenge this view. Which is that judgment?
At your lordship, I have given one short note and date chart. Only date chart. Your lordship, that is available, my lords, perhaps there.
Which is that WP?
WP is 28623 of 2025. First matter.
The subject matter of this petition is substantially similar to the one in WP number?
WP number 35395 of 2025, disposed of yesterday.
Between so and so, heard and disposed of by this court, while order dated 12/1. 12.
Yes.
26.
But incidentally, I was counsel for railway in that matter.
First, similar cases should be treated similarly, being the cardinal principle of adjudication. This case also needs to be decided in terms of cognate decision. First, order in the above below, ordered accordingly, and writ petition is disposed of.
My lord, actively sorry.
All three matters are
same.
Sir, actively sorry.
Yes, sir.
Items are 38, sir. I could not present. 38.
38 we have already adjourned.
Only, sir, because the power disconnection matter, only they have, sir, already inquired the matter.
Which date we have? 38 week. We'll put it next week.
Next.
Hello?
47.
Yeah.
Item number 45, my lord.
44, 45.
45.
What happened to 44? Not yet. 44, nobody.
My lord, at the last occasion, this honorable directed to file the OA petition, copy of the OA petition of the learned cat cutter.
Correct.
But I have recently received the certificate.
You want time or what? Compliance?
Next week, my lord, because today I will file this.
After 2 weeks, at the request of counsel appearing for petitioner. Order dated so and so to be complied with. 26, 11, 25.
Yes.
Okay.
Item 45.
My lord, I am prejudiced, my lord. They have not granted me family pension on the ground of succession certificate, my lord. Even if I have filed legal heir certificate, Aadhaar card, and as well as voter card, my lord.
This is Union of India.
My lord.
Where is your friend? We'll call this after 2 weeks.
My lord.
To enable their counsel.
15, your lordship. 15.
15 February.
15 January.
15 January. Thursday, very difficult. We have posted many matters.
So many matters.
Calling the second week of February 2026 to enable the counsel for the union government to come and argue. Yes.
20.
Second week of February.